My lord, I have filed a civil revision petition that has been listed tomorrow in item number 10. But we have also filed an IA that has not been listed. Can it be taken up tomorrow?
Please, option.
Matter, Millard, the RSA, which was listed on last two occasions, but it did not reach Millard. Millard, I'm requesting for a specific date after the vacation, Millard, subject to convenience, Millard.
For
From
hearing,
station, so it's a bit of a difficult.
for hearing,
Millard,
at what stage?
Millard, it's for final hearing, Millard, hearing.
10 September.
Could it be the July or August, Millard, someday? Because the problem
It
is
will
the
be
2017 appeal, Millard, and
It will be
We-
difficult. We are already full.
there's an execution in a connected matter.
August
Getting
also.
stuck because of this, the pendency of the RSA, Millard.
25th August.
Obliged. Yes, sir.
Please, Lord. My lord, I am praying for listing on a RSA for withdrawal tomorrow, Lord.
Okay.
Obliged, Lord.
May I plead your lordship, I beg to mention supplementary item number 21, my lord. My lord, matter may be list after vacation immediately, my lord. My senior is out of station, my lord.
Heard Miss El Wazida, Learned Counsel for the item number,
21, my lord.
Learned Counsel for the happy. You have informed the other side.
No notice was not issued, my lord.
Okay. Who prays for an adjournment? Or on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed. 29.
My please, Lordship. My lord, I am preparing for listing a CRB, fresh CRB, Lordship, for motion, Lordship. Monday, Lordship.
When have you filed?
We filed today, Lordship.
Then it will be no mentioning. It will not. Next week is a motion week. It will be automatically listed within 2 days.
Finally,
What is the urgency?
urgency is they are going to execute the order, Lordship.
What order?
Order in the miss case, Lordship.
What was the order? You don't know. So no mentioning without proper instructions. It will be automatically listed.
Lordship.
Item 1.
Yes, may I please, Lordship? This is a petition section 227 of I. Lordship, I am challenging the order which is page 28, Lordship. Lordship, the context of the case is that petitioner before Lordship enter into agreement with the respondent for selling a plot of land only 8 lesser. Accordingly, some amount was received by the petitioner. Thereafter, procedure started. NOC was issued and obtained by the petitioner from the deputy commissioner as well as municipality board. So after obtaining the permission from the deputy commissioner, the respondent did not turn up for execution of the register sale deed. So that is the main issue of this title suit, Lordship. Thereafter, after expiry of the time, they approached the petitioner for execution register of the sale deed, Lordship. So after expiry, register cannot be done. So they filed the title suit for under Specific Purposes Act for registration of this land, Lordship. So we appeared and we filed our written statement, Lordship. So they filed their PWs and cross-examined. The issue is that when the matter come for our DW, Lordship, the petitioner did not contact with the council. 2-3 adjournment taken by the council, Lordship. Then on 28, Lordship, the engaged council filed a petition that as due to non-communication of the petitioner, he is not interested to continue the case. This
20.
petition, Lordship, comes in page 28, 27, Lordship. This is the petition filed by the council. Page 27, Annex 3, Lordship. Today, the instant case is fixed for cross-examination of DWs, Lordship. The defendant is neither communicating nor providing any instruction regarding the case, and due to the said reasons, the engaged counsel is not in a position to take further step in this case. As such, the interest of justice, the learned counsel has intended to withdraw his wakalatnama from this case, Lordship. This is the petition filed by the engaged counsel. On getting this, so accordingly, Honorable Court passed the order. That is in page 28, Your Honor. Today, case is posted for cross-examination of DW last chance, Lordship. AC report a cost payment received so and so. Both sides are duly represented by their counsel. But petition number so and so learned counsel of the defendant, Sri Mukesh Kumar Prasad, has intimated that the defendant has neither communicated nor provided any instruction to him regarding this case, and he is not in a position to take further steps in this case. He has prayed for allowing him to withdraw his Ukalatama. Had both sides reduce the case record. Landed counsel for the defendant to intimate his decision to withdraw the Vakalatnama to the defendant in writing and submit a copy of the intimation to the court for further order. By the last order, the last chance for cross-examination of DW was allowed. Today, too, the DW are absent without steps. Hence, it appears that the DWs are not willing to cross-examine. The earlier prayer for adjournment for cross-examination of DW are allowed with cost. The defendant has not deposited the cost till date. Hence, evidence on affidavit filed for DW 1, 2, 3 are hereby expanded as they have not appeared for cross-examination. Next, there is no prayer for calling any official witnesses for a defendant side. Defendant side evidence is hereby closed. Fix so and so for intimation on withdrawal of Vukalatnama, cost payment, receipt, and argument lawsuit.
What is the wrong?
No wrong
here?
lawsuit.
Then
So, yes.
how I can
Yeah, no, no.
interfere?
After that, the client communicated with the counsel and now he is interested to continue the case. There is no wrong in the order, but my only prayer is that the same counsel is engaged, he is continue the case. No, only the prayer is that petitioner defendant in the suit may be allowed to adduce evidence. Evidence is there.
No, if there is no
No,
wrong,
no, no,
how?
no, that part I am saying, Lordship.
Then
For-
how
no,
can
no.
I interfere?
Yes, yes.
Then
No, because it is
your
a-
petition is liable to be dismissed.
yes, Lordship.
If there is, yes, then I will dismiss it.
Yes, Lordship. I'm
Then I
saying-
am dismissing it
Yes,
without.
no. I'm saying that as there is no communication between the counsel and the defendant, so under no circumstances, when the matter is knowledge lordship, then it can lawful. So at the same time, so far the plaintiff is concerned, the plaintiff itself admitted that there is no latches on my part. It is in page 15, last two lines lordship. Page 15 in the plaint lordship. After the expiry of the couple of months, the plaintiff went to the defendant and
No,
requested.
no, I am not going into.
Yes, lordship. So they are.
In spite of repeated chances given to you by the trial court,
Yes, sir.
in spite of imposing, how much cost was imposed earlier?
2,000 only. That I have deposited, lordship. That is page 2036, lordship. Cost I have deposited, lordship. In the
But the order says that.
Yeah.
Oh,
order
in
said that
spite-
day I did not, but when after getting
In
information.
spite of
Yes.
imposition of costs, you did not turn up.
Yes, lordship. That is the order in 28. After getting information on next day, the petitioner turned up and he deposited the cost rupees 22,000. That is in page 36, lordship. I enclosed my cost, lordship. So I may be given an opportunity with any cost, lordship, so that my case will stand. Because being petitioner, I'm the petitioner defendant main suit. Plaintiff admitted it is his fault, lordship.
What is the stage of the trial?
This now is an argument stage, lordship. My evidence is closed, lordship. I have submitted my evidence in affidavit, lordship.
When
That's
is
the
the,
only-
when is the next day?
It is last date, next date is 3/7, lordship. So one last opportunity may be given so that my evidence may be come up, lordship, in the record. Lordship. It is only submitted, I have to cross-examine, lordship. And their plaintiff is saying that it is their fault, lordship, for non-execution of the said deed, lordship.
No,
Yes,
those,
lordship.
those questions are
Yes,
not
lordship,
for
yes.
consideration.
So far the order is challenging, I am challenging, it is my fault and fault of my client, lordship, due to non-communication. And then when he appeared, he deposited the cost, lordship, page 36. So lordship may be allowed as a last chance to my client if he appeared, so case may be continued. So for the order is concerned, there is no latches on the part of my client, lordship. And it is the mistake of my client for non-communication, lordship.
Heard Mr. D. Dev, the learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Swapan Sutradhar, impugning the order dated 28/1/2026 passed by the Court of Learned Civil Justice Senior Division, Borpeta, in title suit number 48/2020, whereby the evidence adduced by the witnesses for the defendant within bracket present petitioner were expunged due to failure on the part of the witnesses, namely DW1, DW2, and DW3, to present themselves for for the purpose of cross-examination. Stop. The learned counsel for the Mr. D. Day, the learned counsel for the petitioner fairly submits that there has been laches and negligence on the part of the petitioners, witnesses in not presenting themselves and presenting themselves for the purpose of cross-examination. However, he submits that if the evidence adduced by the DW1, 2, and 3 are expunged, the version of the defendant side may not be considered by the trial court, and the suit will be decided entirely on the basis of the evidence adduced by the plaintiff's witnesses, which he submits that would be prejudicial to the interest of the present petitioner. He also submits that the petitioners are how many petitioners? So
One petition, Your Lordship.
the petitioner is ready to produce all his
Yes.
witnesses on the next date fixed, that is on
7.
3/7
Yes.
2026, as the matter is fixed for argument. Stop. I have considered the submissions made by learned counsel for both sides. Learned counsel for the petitioner, and have gone through the materials available on record. It appears that the trial court has, on an earlier instance, imposed cause for failure on the part of the defendant within bracket present petitioner to present his witnesses for the purpose of cross-examination. Though the said cost of rupees 2,000 has been paid, however, in spite of that, on the fixed date, the petitioner failed to present his witnesses for the purpose of cross-examination.
Lordship, I paid on the next day, Lordship. It's 36. Next date I paid. When I appeared in Lordship.
Stop. Though there appears to be no infirmity on or error in the impugned order passed by the trial court. However, this court is of considered opinion that since the petitioner is ready to present his witnesses before the trial court for the purpose of cross-examination on the next date fixed, the purpose of the justice would be served if the trial court has the version of both the sides before it reaches a conclusion in the pending trial. As such, the impugned order is interfered with, and the observation of the trial court regarding expansion of the evidence of DW 1, 2, and 3 is concerned, same is set aside. On the next date fixed, that is 3/7/2026, the trial court shall give a date for presentation of witnesses, namely DW 1, 2, and 3 for cross-examination. And on that day, the petitioner shall produce all his witnesses for the purpose of cross-examination. Stop. The this is subject to payment of cost of rupees 10,000 to the by the no 10,000 to the petitioner by the petitioner to the respondent, that is plaintiff side. The payment of cost shall be condition precedent for allowing the cross-examination of the plaintiff's and defendant's witnesses. This court is of considered opinion that the interest of the plaintiff is taken care of by this court by imposing costs on the present petitioner and making same as condition precedent for allowing the cross-examination of the plaintiff's witness, defendant's witnesses. Hence, notice to the respondents in this CRP appeal, in this civil revision petition IO is waived, and with above observation, this in CRP IO is disposed of.
Item 7 from supplementary.
May I plead your lordship, lordship, last occasion, your lordship call for this lower court report, my lord.
What report?
Report from this landed district judge, my lord. My petition not accepted for this court, my lord.
Oh, yes. You have gone through the report.
No, my lord.
The report says that when your lawyer counsel at the district court went there to submit the petition under 24, he was advised to get it typed out as the handwriting was not legible. And then you agreed with the same and took back the petition.
My lord, that if the present petition is maybe disposed of, my lord, I remanded back this matter. Petitioner approached before this court, my lord.
Yes. Heard Miss El Wajida, learned counsel for the petitioners. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioners praying for transfer of the title suit number 213/2020 from the Court of Learned Civil Judge Junior Division number 2 to the Court of Learned Senior Judge Civil Judge Senior Division Hailakandi. Stop. As the petitioner has approached this court instead of approaching the appropriate court, that is the Court of Learned District Judge Hailakandi, a query was posed to the learned counsel for the petitioner as to why same was done. On this, the petitioner's counsel informed this court that the petitioner initially approached the Court of Learned District Judge Hailakandi. However, the petition was not accepted by the Learned District Judge and was returned to the petitioners. Stop. On this, a report as regards the allegations made by the learned counsel for the petitioner, was called for from the from the learned district judge Hailakandi. Today, the district judge has submitted report dated 16/6/2026, in which it is admitted by learned district judge that the concerned lawyer of the petitioners presented the transfer petition at around 12:30 p.m. and requested the bench assistant to put up the same before the learned district judge. However, as an earlier instruction has already been issued to the office staff by the learned district judge that in event of belated filing of such petition, same should be put up before district judge before registration of the same. It was not registered and put up before learned district judge before registration. It also appears that from the report of learned district judge that the learned district judge advised the counsel to get the petition to be typed and accordingly the same was collected back by the counsel. Stop. The instructions of learned district judge regarding putting up of petition even before assigning a petition number or registration number to it before the district judge does not appears to be in accordance with rules. Any petition or application filed by the party, any petitioner has to be registered and thereafter put up before the court for passing a judicial order thereon. If there is any defect in filing of the said petition, same may be reflected in the judicial order. However, verbally, the practice of giving verbal advice to the council by the courts without registering the petition cannot be encouraged. Hence, this transfer petition is disposed of with a direction to the petitioner to approach before the Court of Learned District Judge Hailakandi. And if such, when will you approach?
Any date may be fixed, my lord.
Within a
Next
week,
week.
within a week from the date of this order. On such filing of the petition, the same shall be registered in accordance with the rules, in accordance with the provisions of High Court civil rules and orders, and same shall be put up before learned district judge for passing in judicial order thereon, after considering the after considering the same on merits. With above observation, this transfer petition is disposed of.
Acknowledge, your lordship.
Item 18.
May I please, your lordship?
Before my learned friend starts, my lord, I have got a preliminary objection regarding entertainability of this petition. May I submit that? When this civil revision was filed, challenging an order of the district judge in a proceeding under the Public Universities Act, a writ petition was still pending. That writ petition has been listed today for withdrawal. They have perhaps in the meantime withdrawn. But as at the time of filing of this civil revision petition, so
This one?
Yes, ma'am. Against the same order, there are two proceedings pending. One this and the other is the writ petition.
Writ petition is still pending.
This has been, my lord, listed for withdrawal today.
And
They
it will
may
withdraw,
have
ma'am,
withdrawn in the meantime.
in the morning, ma'am.
But the fact remains that, my lord, when this revision petition was filed, challenging the same order, writ petition under 226 was pending.
But now it is not pending.
Now, question is, my lord, whether at the, at one point of time, my lord, two proceedings can be
No.
filed, my lord, against the same impugned order. That is my, my lord, primary submission.
And if in the meanwhile, one of the petition is withdrawn, whether the second one survives.
The ideal situation is that, my lord, they have to withdraw this that petition, writ petition, and thereafter, my lord, file this petition.
Yes, that
Is the ideal situation.
yes.
That having not been done, my lord, they need to, my lord, take back this and file it again, my lord, showing the, my lord, withdrawal order. Because, my lord, at the time of filing of this petition, my lord, challenging the same order, there was a writ petition pending. I leave it to your lordship.
No, but presently it is not pending. It
No,
will
my lord,
be.
we
Now, what is your prayer?
Then, my
What?
lord, this should not be entertained, my lord, because it was filed when another.
Where is the withdrawal order?
My lord, today morning, we had, my lord, the matter was posted before court number 6, my lord, and court has allowed us to withdraw with a liberty also was granted, although we have made a mention that we have already filed a CRP before this honorable court and the same case is pending, and the council appearing
No.
for IOCL was also
Show the
present.
withdrawal order. You are admitting that.
It has been withdrawn today itself.
Yes, ma'am.
So at least let the withdrawal order be there.
My lord, in fact, in paragraph 26, they have admitted it, my lord.
We have
This
also
petition
stated in
also.
this paragraph.
We said that, my lord, the repetition is
Yes,
there,
I
we
think
withdraw it. That is what they have said. But the question is, my lord, whether at the same point of time, my lord, the registry can enter in two petitions on the same subject matter.
Statement
Two,
code,
my lord, different.
Yes, now what should I do?
Statement code.
My lord, my submission will be that your lordship may allow them to withdraw this and file it again along with the withdrawal order.
No,
There is nothing to laugh about.
no, I'm sorry.
No. There is nothing.
There is nothing to laugh about.
No,
The
no, no.
question is very simple, my lord. Whether at one point of time, two proceedings can be pending, my lord, entertained by the registry, one under 226, one under 227. That is the question.
Yes.
My lord, we have already mentioned about that at page number 59, my lord, para number 26. Para number 26, my lord.
Page number 50.
59, para number 26, my lord. It's a very lengthy revision application, my lord, because of various reasons.
No, just a minute. Yes.
That the petitioner begs to state that initially, before filing the instant civil revision petition, he had inadvertently, by invoking the provisions of Article 226, had filed a writ petition on 12/6/2026 before the Honorable Court, which was registered and numbered as WPC number 3190/2026. However, upon realizing that the petitioner should have filed an application under Article 227 of the Constitution of India, had filed the instant revision petition, assailing the legality and validity of the order dated 3/6/2026, passed in Miss Appeal 2/2021 by learned court of the Honorable District Judge Tinsukia. The petitioner therefore undertakes not to press and to withdraw the above mentioned writ petition, that is WPC number so and so, as and when the same is posted before this honorable court. It may be pertinent to mention herein that due to paucity of time and due to the urgent nature of the case relating to his eviction from the subject land in question, the petitioner has immediately, as a measure of abundant caution, has filed the instant civil division petition, being the appropriate and efficacious remedy before the honorable court under the law holding the field. So that opportunity came today itself, my lord, and we have already withdrawn that.
No, but that order is not before this court.
That matter is, of course, not before this court. And my lord,
Because you have admitted that before withdrawal of WPC, you have filed this
yes,
CRP.
madam.
That,
Yes.
so we'll take it up tomorrow.
My lord, tomorrow is the last date for the eviction of
Today,
mine.
sir.
No, 18. Yes, last date for eviction of mine. And that was the reason why we filed the revision, when we came to know that only the revision lies, not the writ petition. And that's why we have made a mention here also that though we have filed, but we had to withdraw. Luckily, my lord, that matter came up today and we have already withdrawn.
This is the harm in getting this concern.
Let that withdrawal order be before this court.
We can, but my lord, as the eviction is there, let that be a stayed till your lordship hears that matter.
No. It is apparent from para 26 that you filed this petition during the pendency of writ petition.
True, very true.
Though I am not doubting your submission, but there must be something on record to indicate that the
My lord, it will take 1 or 2 days time to obtain the order, certified
Wow.
copy of the order, and to make it by way of affidavit before this honorable court.
No, withdrawal
But-
order, it gets online.
We can produce, my lord. Can produce, my lord.
Then we'll list the matter tomorrow. Heard Mr. A. Sattar, learned counsel for the petitioner. Also heard Mr. M. K. Chaudhary, learned senior counsel, assisted by Mr. Yes, what is your name? Assisting counsel. W. Rahman. At the outset, learned senior counsel for the respondents raised a preliminary objection regarding the maintainability of this civil revision petition. He submits that assailing the same order which has been impugned in the civil revision petition, the petitioner had filed a writ petition bearing WPC number 3190/2026, and before withdrawing the said writ petition, that is during the pendency of that said writ petition, the instant civil revision petition has been filed, which is apparent from the averment made in paragraph number 26 of the instant civil revision petition. On this, Mr. A. Sattar, the learned counsel for the petitioner, submits that the writ petition number 3190/2026 has already been allowed to be withdrawn, and same has been dismissed on withdrawal by a coordinate bencher, this court today itself. And he submits that some time may be granted to place on record the said order before this court. The prayer is allowed. Let this matter be listed tomorrow.
My lord, let it be listed on Monday, my lord, because tomorrow if the order is not available in that way,
Let this matter be listed Monday,
on Monday, yes.
22nd of.
And till then, my lord, may I pray for interim relief in the form of, my lord.
No, we are not entertaining it unless your order is before.
Publish your lordship, publish your.
No coercive action will be taken, sir. No coercive actions.
IOC is already there, my lord. Let them take no coercive action.
Let's not take coercive action.
As
I am verbally requesting before honorable court, let there be no any coercive action.
I do not know what has happened in the ground while that instructions I write.
as it is objected to, I am not passing any judicial order.
Publish your
It is
lordship.
Item 19.
No, judicial order will be.
Some protection because my lord.
Not at their back.
Publish your lordship, publish.
On Monday, wait till Monday.
The date is, my lord. today,
Monday.
22nd.
Item 19.
May I please, your lordship? Your lordship, kindly pass over for time being, your lordship. Much obliged.
Order. Item 3.
Well, office note dated 18/5/2026. We have taken steps. But address possibly not. We have taken steps on the address given by the respondent. Last occasion.
Steps on notice is not yet complete.
Corrected.
You are appearing for,
That is left.
Ms. Chaudhary, you are appearing.
3 and 4, but I have given the correct address of respondent number 2.
Two.
And respondent number 1 already died. They ought to have filed an application praying to correct the cause title. Thereafter, only they can take step, Lordship, I think, after amendment of cause title. Otherwise, registry will send in original address again.
But on my lord, corrected address we said it.
No, but
was
what
for
is the
that.
corrected address?
Well, they supplied to us.
You have to correct the cause title.
That is that.
Otherwise, how will we verify
But
that?
registry
To
may
what
not,
address?
1 week, 2 weeks time maybe given.
Heard, Mr. Yeah.
We have
M.
urgency in this matter,
Oh.
Lordship, so we made a
Eh.
mention, so Lordship, an early date may be given.
Heard Mr. N. Hawk, learned counsel for the appellant. Also heard Miss R. Chaudhary, learned senior counsel assisted by Miss S. E. Murtaza, learned counsel for respondent number
3 and 4.
3 and 4. Office note dated 13/5/2026 shows that the notice issued to respondent number 2 has returned with an endorsement within inverted comma, no such person in the address, comma, RTS. Learned senior counsel for the respondent number 3 and 4 submits that though the respondent has, though she has furnished the present address of the respondent number 2 to the learned counsel for the appellant, however, no correction of cause title of the memo of appeal has been done, showing the address, showing the new correct address of the respondent number 2 therein. And which, comma, which is required before sending the notice to respondent number 2 at the said address. Stop. Learned counsel for the appellant seeks 2 weeks time for submitting a corrected cause title in the instant memo of appeal. The prayer is allowed. Let this matter be listed.
Lordship, respondent number 1 also died, so they are required to pray for striking out the name of respondent number 1. As because respondent number 2 is son of the Ahmed Ali and she was wife of Ahmed Ali.
So no other legal heirs.
That I do not have. I will take instruction if any other legal heirs are there, Lordship.
Learned counsel, senior counsel for the respondent number 3 and 4 further submits that the respondent number 1 has in the meanwhile expired. However, the respondent number 3,
Two.
2 is the son of respondent number 1 as well as respondent number respondent number 1. Learned counsel for the appellant also, in this regard, learned counsel for the appellant further pays for 2 weeks time to take instructions and also take necessary steps in that regard. The prayer is allowed. Let this matter be listed. 31 July.
Obliged.
Deeply of.
Item 4.
May I please your lordship? My lord, an interlocutory application, my lord, with the prayer for, my lord, restoration of a second appeal is, my lord, here. My lord, what has happened due to some communication mistakes, my lord, may kindly turn to page 15, my lord, of the IA, my lord. My lord,
Restoration means it was dismissed.
Lord, on the Lord withdrawal, my lord, the taking into account the above, the instant appeal stand closed on withdrawal, my lord.
So how it can be restored?
My lord, my lord, may kindly peruse the first paragraph, my lord. So and so appearing on behalf of the appellant submitted, the appellant would not like to proceed with the instant appeal, my lord. My lord, there was no any such instruction has been advanced. Some communication mistake may be there, my lord. So,
No,
my lord,
how this can be encouraged? Otherwise,
my lord,
court will stop believing lawyers.
my lord, that is one thing, one
If
aspect. I
today
cannot, I
you
cannot,
say
yes,
that
yes, my lord, today I am.
tomorrow you come with a petition that
My
no such instruction is.
My lord. That's why, my lord, withdrawal is, my lord, always, when I preferred, my lord, with a petition, my lord, or at least some written instruction is required, my lord. But here, my lord, otherwise their rights, my lord, of the appeal is now being wiped out, my lord, due to this.
Whether the in appeal the respondent appeared.
No, my lord, because appeal was not even not admitted, my lord. Before the admission, it had been, my lord, withdrawn, my lord. And my lord, when the execution.
Where is the provision?
My lord.
Where is the provision for doing?
Provision is very, my lord, we have searched, my lord, but this provision is very limited, my lord.
Rule
That's why,
19 does not help.
my lord, my lord. Now, my lord, the execution proceeding had also been started, my lord. That's why when the execution started, then we could learn, my lord. Page number 22 is the last order, my lord.
That too, you are coming after more than
My lord,
1 year, 4 months.
my lord. My lord, because this last, it is on fixed on 16th. My lord, what has happened? The Gaubra had informed us that such thing is going to happen. So your appeal had already been withdrawn. So then only, my lord, we immediately rushed before my lordship.
Then you convince this court that this can be done.
My lord,
Some
it is.
authority.
My lord,
Do some research.
my lord, some judgments are there, my lord, when the, my lord, submission is made by a lawyer, my lord, without any written instructions or without any, my lord, petition, my lord, then that order, my lord, may not be, my lord, subject to correction, my lord, with all respect, my lord, may not be binding on the appellant or the petitioner, my lord. If my lord fixed date, my lord, I can satisfy with the judgments also, my lord, on that line. But my lord, whether after the withdrawal, my lord, when the petition is closed, my lord, on
Whether
oral.
it can be again reopened.
My lord, that is a matter.
Otherwise, there will be no end to it.
That is correct, my lord. That I cannot.
Every second day somebody will come.
My lord, what I have to submit fairly before my lord. My lord, this is the, I have repeatedly asked the, my lord, appellant that what was the exact scenario, my lord. Exact scenario was there, my lord, that the no such any instruction had been advanced.
Who was the counsel?
My lord, I cannot pronounce. My lord, may kindly turn page 15, my lord. I cannot pronounce the name openly, my lord.
No, if you are casting aspersion on the, it is a blame on the council also.
I'm not, even, my lord, I am not blaming some communication. They have said that some communication gap was there, my lord. I have.
This has to be verified.
My
The
lord,
council has to be.
that is correct, my lord. That is also correct. We are in a very awkward situation, my lord.
You have named the council.
My lord,
Who
page
made?
number 7, my lord. If just for a moment I am troubling my lordship with paragraph, my lord. Paragraph 4, my lord. Lord, as we have come up with an application with an affidavit, my lord may take this as an, my lord, statement on oath, my lord.
We don't know who is the council.
My lord.
Such, it is a vague petition.
Not vague, my lord, but the facts is like that. My lord, if my lordships allows me, my lord, then with those judgments, my lord, that the, in such a situation, my lord, if such submission is made,
Mr.
my lord.
A.R. Puya, Learned Senior Counsel, assisted by Mr. N.Z. Chaudhary. This interlocutory application has been filed by the applicants for revival of regular second appeal number 185/2024, which was dismissed on withdrawal, which was closed on withdrawal by this court on 24/2/2025. Closed on withdrawal by a coordinate bench of this court on 24/2/2025. Stop. when specific queries were put to learned senior counsel as to under what provision in such a scenario the regular second appeal may be revived or readmitted, learned senior counsel sought some time to bring some authorities on record. It also appears you have to also bring the facts, complete facts.
We'll file an additional affidavit. Bring those facts.
Learned senior counsel also sought leave of this court to file an additional affidavit to bring certain facts on record, which may be necessary for consideration of the instant interlocutory application. The prayer is allowed. Let this matter be listed well.
My lord, on next week, last day before the vacation, my lord. Some urgency is there, my lord, because execution may happen at any time, my lord.
Before vacation.
Next week, Thursday, my lord. My lord.
25th. Otherwise, I am not convinced.
My lord, it is difficult, my lord. We'll try, my lord. We'll try if I can convince my lordship.
Okay. 25th
My lord.
June.
Obliged.
My lord, delay, my lord, 95 days, my lord, in filing the CRP email. Is listed for the first
Will
time.
he issue notice?
Yes.
Heard Mr. R. Chakraborty, learned counsel for the applicant. This interlocutory application has been filed by the applicants, praying for condoning the delay of 95 days in preferring the connected civil revision petition. Issue notice to the respondent. The petitioner shall take the applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on July 10,
July.
31st July.
My lord, may I pray, my lord, pro forma respond number 4, my lord. Notice, my lord, at this stage, my lord, may not be required, my lord.
No, first you take step. If there is some difficulty, we may waive notice later on.
And my lord, can it be in additionally, my lord, Dosti mode, my lord,
Yes.
because of the urgency?
Additionally, the applicant is also allowed to issue, no, also allowed to serve notice on the respondents by way of dusty mode. Stop in the event the applicants are able to serve the notice by dusty mode, they shall file an affidavit in compliance thereto on the next date fixed. Please check.
Obliged.
Item 20, supplementary list.
Here we go, Lordship. They have furnished the names of the legal heirs of respondent number 1. We need some more time to file substitution petition, Lordship.
Heard Miss, what is her name?
R. Shah.
Heard Miss R. Shah, learned counsel for the appellant, who seeks some more time to take steps for filing appropriate application for substituting the legal heirs of deceased respondent number. Respondent number 1. Respondent number 1. The prayer is allowed. Let this matter be listed again. 31st July.
Item 23.
May I please, madam?
Yes.
My lord. There are 2 IAs which are pending, my lord. There is one IA is 1455, my lord.
For
This is for delay condonation, my lord. I was directed to take steps Accordingly, steps was initiated. I have taken the steps. But the office note says that the AD card has not been received by the section.
When have you taken steps?
As far as I recall, my lord, immediately after the order was for within 4 to 5 days, we have taken step. Second time the matter was listed on 3/6/26.
We will direct the registry to place the postal track consignment report.
Yes, madam. That will happen.
Heard Mr.
K. Vishwakarma.
K. Vishwakarma, learned counsel for the applicant. On perusal of the office note dated 11/6/2026, it appears that service report in respect of notices issued to the respondents are awaited. The registry is directed to place the postal track consignment report of notices issued to respondent number 1, 2, 3 by speed post before this court on the next date fixed. List 16th of July.
My lord, there is one more IA pending, my lord. On 3/6/26, my lord, I made a prayer before the honorable court for the stay of the execution proceeding. My application was pending there. The honorable court observes that since I have filed an application under order 41 rule 5 that cannot be entertained. That is why the honorable court has given me an opportunity to file an appropriate application, my lord. IA number, my lord, 2041, my lord. IA number 2041. This is the first application which I have filed, my lord. After I have, my lord, I may be allowed to give a brief fact of the case, my lord.
No. Before that,
Yes, my lord.
this I has been filed under what provision?
Yes, this IA has been filed under provision, my lord, order 41, rule 3A, my lord.
What is this? What it contains?
For which I am also relying on a judgment, my lord.
No, but what
Yes.
is the statutory provision?
Yes, yes.
Read it first.
May I read, my lord?
Read Rule 3A, Clause 3.
Yes. Where an application has been made under sub rule 1, the court shall not make an order for the stay of execution of the decree against which the appeal is proposed to be filed, so long as the court does not, after hearing under rule 11, decide to hear the appeal.
Okay.
Now, my lord, the similar circumstances has arisen in a case.
What is 3A1?
3A1, my lord. When an appeal is presented after the expiry of a period of limitation specified therefore, it shall be accompanied by an application supported by affidavit, setting forth the facts on which the appeal relies to satisfy the court that he has sufficient cause for not preferring the appeal within such.
How 3A helps you?
3A, my lord.
How it helps you?
Yes, my lord. My lord, first of all, as for 3A clause 1, we are satisfying that condition because there is a delay condonation. IA number 145.
What?
Clause
Clause 1, what it says?
My lord, when an appeal is presented after the expiry of period of limitation, specified therefore. My lord, I
Yes.
have crossed the period.
Then what is required? Read.
It shall be accompanied by an application supported by affidavit, setting forth the facts on which the applicant relies to satisfy the court that he has sufficient cause for not preferring the appeal within such period.
That you have done by filing the other
Yes,
application.
my lord. 1455.
No, how?
Yes.
What for you have filed this 3A application?
This 3A application, my lord, now since there is after the filing of this appeal, my lord, it has come to notice that the title execution case has been initiated, my lord, before the court of the.
No, show me where 3A provides that a stay may be granted under 3A.
My lord, this particular provision has been further interpreted by the honorable court, by the High Court itself, my lord, for which I am relying on that.
Show me.
Yes, my lord.
No, before
Yes, my lord.
showing a decision where the statute helps you. You show from the statute first that this helps me and it was interpreted in this manner. In 3A, I don't find anything regarding.
My lord, this case will help me to understand this statute, my lord. My lord, may I read this, my lord?
Yes.
Yes. An appeal was filed before the lower appellate court against the judgment of the learned Munsif. There was delay in filing an appeal, and accordingly, an application was filed for condonation of delay under sections of the Limitation Act. On that application for condonation of delay, notice was issued. Similarly, is in my case as well. Another application was filed under Order 41, Rule 5, for stay of the execution of the degree. The lower appellate court did not grant stay, only because he held that stay cannot be granted in view of Order 41, Rule 3A. 3, Clause 3. Rule 3A, Clause 3 read as follows. Where an application has been made hinder sub Rule 1, the court shall not make an order for the stay of execution of the degree against which the appeal is proposed to be filed, so long as the court does not, after hearing under Rule 11, decides to hear the appeal. A fair interpretation of Order 41, Rule 3 of the Code of Civil Procedure would be that it requires that the appellant present an appeal after expiry of the period of limitation. It shall be accompanied by an application supported by affidavit stating the reasons for delay in preferring the appeal, along with the memorandum of appeal. After all, Order 41, Rule 3A is a procedural law, and this procedural law must be interpreted in such a manner that to advance the cause of justice. If the power to grant the stay is not given in exceptional cases, this will cause sheer injustice to an appellant who may be prevented from filing an appeal in time because of compelling circumstances. After all, laws cannot be allowed or utilized to cause injustice. In such a situation, the court can exercise the power under Section 151 of the Code of Civil Procedure to grant relief in such a case if the justice demands it. This is the mandate of law, and that is the requirement of law. Accordingly, this revision application is allowed, and the stay application shall be considered by the lower appellate court in accordance with law. With this observation, the civil revision is allowed. My lord, while interpreting this particular statute, my lord,
It does not say that 3 allows the court to grant interim relief, overriding the import of 3A Clause 3. Clause 3 is a specific bar.
yes, ma'am.
This judgment only says that in such cases, 151 can be taken recourse to.
Correct, my lord. Well, my lord, well, once the application was filed under this particular provision, my lord, under Order 41, Rule 5 for stay of execution of the degree. My lord, may kindly see the first paragraph. I'm just referring to the judgment itself.
Yes.
The lower appellate court did not grant stay only because he held that the stay cannot be granted
Yes,
in
no.
view of Order 41, Rule 3A.
How I have understood, if I am wrong, make me correct. This judgment only says that in exceptional circumstances, to override the effect of embargo of Rule 3A Clause 3, an application under 151 may be filed. 3A does not help you. 151 may help you in exceptional cases.
My lord.
So even if we treat your application as an application under Section 151, notice has to go to the other side. It does not say that waiving notice in when is the execution case?
My lord, the execution case is already proceeding, my lord.
When is the next day?
Next day, fix it, doctor, on 31/7/2026.
Before that day, we will fix will issue notice. Abhishek, वो से आई में कुछ ऑर्डर हुआ है. What is the order? How your case is an exceptional case?
Yes, my lord. My lord, I am for the LICA. Now what happened is, my lord, when the plaintiff has approached the learned trial court, they have went under section 108 of the evidence act. What they are saying, the policy holder, the father and the husband of the respondents went missing, and he was missing for almost 12 years. My lord, what happened is, like, we have contested the case and we have said that we have no objection with regard to the first prey. They want a declaration under 108 of the
Okay,
evidence.
we'll issue notice, we'll give a chance to the other side, fixing it before the date fixed by the executing court. And then we will decide.
But otherwise, what happened is it's a public money, so that is why I was thinking that falls under this category, because the reason is if lordship is issuing and
We are issuing notice.
yes,
The next date,
till date, my lord, if I can be yes.
that is the question, whether till
Yes.
the 1455 next date क्या है? 16th of July. Okay. This interlocutory application has been filed by the petitioners in connection with IA number 1455/2026, praying for stay of execution of the judgment and decree dated 13/10/2025 and 29/10/2025 respectively, passed by the Court of Learned Civil Justice Senior Division Sonitpur in title appeal number 4/2025 in the title execution case number 53/2025. Learned counsel for the petitioner has submitted that this application may be treated as an application under section 151 of the CPC in terms of the observations made by a coordinate bench of this court in the case of Ramesh Chandra Kalita versus Meera Patwari and others, reported in 1997 1 GLT 511. Stop. Learned counsel for the applicant has further stated that the execution case is fixed. Next date of in the aforementioned execution case is on
31/7.
31/7. Stop. This court is inclined to issue notice to the other side. Hence, issue notice. Inclined to issue notice before considering the prayer of the petitioner. Hence, issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16th of July. List accordingly.
My lord, I have a prayer, my lord. I may be directed, I may be allowed to take the consignment number from the registry, my lord, to track down the
No, I have directed the registry to place the consignment.
okay,
Registry will place the.
yes. Similar order in this case also, my lord.
Yes.
Okay.
Item 24.
I'm obliged, lordship.
Oh, in the IA, in
Yes,
the
sir.
IA.
Yes,
Okay,
yes.
okay, okay.
The same here also.
The registry shall, in the event the petitioner takes steps in the this interlocutory application, the registry shall furnish the consignment number of the notices sent through speed post to the learned counsel for the petitioner, so that he may place the track consignment report before this court on the next date fixed.
I'm obliged.
Next is
Yes.
the lawsuit, my lord.
Item
Well,
number?
This 24, my lord. In 24, my lord, I had filed this interlocutory application for grant of a temporary injunction against the, my lord, construction activities which is underdone by the, my lord, appellants in the RSA. Now, in the RSA, my lord, lordship will kindly see order dated 2/6/26, my lord.
Two six.
26. There's a last order on which that RSA was fixed, my lord.
Yes.
In that, my lord, paragraph 3 of that order, my lord, it has been held that, my lord, this proceeding has already abated because, my lord, the defendant number 1 had expired and the notice of the expiry had been given in due time, my lord, in exercise of powers, my lord.
How many defendants, respondents are there?
2, my lord.
Only one has expired.
1 has expired, my lord. And, my lord, against that, my lord, when the notice was given, my lord, saying that he has expired, till today, my lord, no petition for substitution or setting aside of the abatement has been filed, my lord. In the meanwhile, they are, my lord, going on and making constructions over those lands, my lord.
Who is making construction?
These, my lord, the legal heirs of the defendant number 1 and 6. The appellant number 1 and 6, my lord. Because they have stated that even the appellant number 1 and 6 has expired, but
No, who expired? Defendant or
1,
appellant?
6 and 8. The appellant number 1, 6 and 8 has also expired.
Okay,
And, my lord, the respondent number 1 has also expired.
okay.
And there is nothing on record, my lord, to even to substitute or to bring on record or set aside the abatement on the death of these appellants, as well as the respondent, my lord, till date, my lord. And therefore, there is a finding that
Who are you?
I am, my lord, the plaintiff.
And in this appeal,
In this appeal, I am the respondent, my lord.
respondent number?
1 and 2. I am now, my lord.
One
this
has
petition-
expired.
Expired. The petition has been filed by respondent number 2, my lord.
Okay. The appeal has abated against 1, 6 and 8.
Yes, my lord. As also respondent number 1.
As also,
Yes, my lord. I will file substitution petition, my lord. They have already come, my lord. The heirs of appellant number 1, 6 and 8, my lord. Yesterday they came, my lord. I will file, my lord, substitution petition along with other relevant petitions.
Now, that they may do at any time, my lord, but when there is a specific finding that the proceeding has abated, that is, it's abated. So, my lord, now what happens is, initially, along with this appeal, there is a, my lord, miscase number 1069 of, my lord, 2010. That is there. And I had ordered it at 9/4, my lord, 9/4/2010. That miscase has been allowed my staying the further operation of the, my lord, judgment and appellate decree, my lord.
the decree is in your favor.
Yes, my lord.
You were the plaintiff.
I am the plaintiff.
You stayed by order 9/4/2010.
So because now this, my lord, it is a direction is there that the proceeding is abated. That means this, my lord, order.
Proceeding
marked-
has abated as against specific
Yes,
respondents only,
my lord.
but entire appeal has not abated.
In my submission, it is, my lord, that because, my lord, there cannot be bifurcation of the appellants, my lord, they in the same property, my lord. So, my lord, appeal has abated as a whole.
No,
Even then, my lord.
appeal has not abated.
Even then, my lord.
Against
my lord,
specific,
today, my lord, even then, if the appeal continues, my lord, if the appeal survives, my lord, this petition has been filed by the, my lord, respondent number 2, who has said that, my lord, the appellant number 1 Alerts of appellant number 1 and 6, they are making permanent structures, my lord, over the land. I have given photographs also, my lord.
Yes, that cannot be done.
That cannot be done, my lord. So that may be
Unless-
stayed.
Regarding that, my lord. I
Let
checked
him, let him come, my lord,
and
and my lord, that may be
we
stayed, my
filed
lord.
a objection, my lord, against this road.
And it's a prayer I have
I
made, my lord, till date, my lord, till he comes up with, my lord, whatever our objection, my lord. Let status quo as on date be maintained and no further constructions be made, my lord.
Yes, Mr. Chauhan. Now there is no stay operative in respect of appellant number 1. Since the appeal has been abated, has already by operation of law.
I'll
So
file
there is
it.
no stay order. So if there is no stay order,
That being ordered as title appeal decree, judgment and decree is served, it revives.
what was the decree?
Decree was, my lord, declaration of right title in interest and, my lord, eviction of these appellants, my lord, and to recovery of khas possession on my behalf.
When
Stay was there, my lord. On 9/4/2010, my lord, stay was there.
but stay gets loses its force after abatement of the appeal. If appeal is abated, there is no stay remains.
My lord, since there was no communication with me.
What is your submission in I?
My lord, I'll file another objection.
Let him file objection.
Yes,
Till then, my lord, status quo and further constructions may be restrained, my lord.
Heard Mr. G. Chaudhary, the learned counsel for the applicants. Also heard Mr. R. Chauhan,
arrest you.
R. S. Chauhan, the learned counsel for respondent number,
All the respondents.
All the others.
all the respondents. You are for the appellant,
Appealing, yes.
appellant slash opposite party. And you are for respondent number?
Both 1 and 2, but now 1 is not there, so for 2 I am
Respondent
there.
number
2.
1 and 2 slash applicants. This application under order 39 rule 1 and 2 read with section 151 of the Code of Civil Procedure has been filed by the respondent number 1 and 2 slash applicant in connection with the connected RSA number 65 slash 2010, praying for grant of temporary injunction against the appellants slash opposite party, restraining them from making permanent construction over the decretal land, over the suit land, or to change the nature and feature of the suit land, and of the court to create any third party rights for the suit land. Learned counsel for the applicant has submitted that at the time of admission of the connected regular second appeal, the appellants also file an miss case number 1069/2010 under order 41 rule 5, and by order dated 9/4/2010, the execution of the judgment and order of the impugned judgment was stayed. Stop. He further submits that in the meanwhile, the appellant number 1, 6, and 8 have expired. All three died on a same day.
No, my lord. They have died before, my lord. This respondent number 1, my lord, Pramod Deka, he expired on, my lord, 2nd of March 2025.
Right. And from where you are saying?
My lord.
2nd of March,
I have, that's reflected in the earlier order dated 2/6/26, my lord,
that
in the
only,
RSA.
only respondent number 6. Oh, it is okay. Tell me. Expired. The appellant number 6 expired on 23/1/2025, whereas the date of expiry or date of death of other two appellants are not known. He further submits that in the date of death of other two appellants are not known. He further submits that in the meanwhile, the respondent number 1 has also expired on 2nd of March 2025. He submits that after the death of the aforesaid appellants as well as respondent, no steps for substituting their legal heirs have been taken by the appellants within the prescribed period of limitation, and as such, he submits that the appeal has abated against the said respondent. He, however, submits that though the appeal against respondent number 1 has already been abated by operation of law, however, the successor in interest of the said appellant are constructing permanent structures over the decretal land, and therefore he has prayed for grant of temporary injunction against them during the pendency of the connected regular second appeal. On the other hand, learned Mr. R.S. Chauhan, learned counsel for the respondent, submits that in the connected appeal, the learned counsel for the appellant, submits that in the connected appeal, the appellant would be filing appropriate application for setting aside abatement as well as for substitution of the legal heir of deceased appellants / respondent. He also submits that some time may also be granted to the opposite party to file a written objection against the prayer of the applicants in this interlocutory application for grant of temporary injunction. The prayer is allowed. When will you file? When?
After 2 weeks.
Let this matter be listed on 31st July. In the meanwhile, as apparently from record, it appears that the appeal in respect of appellant number 1, 6 and
1, 6 and 8.
8 as well as respondent number 1 has already abated. Their successors in interest shall maintain status quo in respect of the suit land till the next date,
And no further construction.
and shall not continue any construction over the suit land till filing of objection by them in this interlocutory application. List accordingly.
On 31st of July. I'm deeply obliged.
Binding item 19. May I please, your lordship?
Yes.
My lord, what has happened in this case?
The petitioners before your lordship are occupancy tenants, my lord. Under, my lord, the Assam Temporary Settled Areas Tenancy Act. My landlord is, my lord, Sanjit Ram Fukon, respondent number 2 and respondent number 3. We are in occupation, my lord, in the land since last, my lord, 50 years. My lord, our predecessor, forefathers were cultivating the land. And thereafter, my lord, Khatian was issued. Your lordship will find, my lord, Annexure 2, page 17 is the Khatian issued in the name of my grandfather. My lord, page 17A is the vernacular portion, my lord. Page 17A. As your lordship got it, my lord. And we are, my lord, continuously uninterrupted in occupation of the suit land, my lord, without any disturbance from any quarter. Now, my lord, the respondent number 1, my lord, in collusion with the respondent number 2 and 3, who happens to be my landlord, my lord, they, my lord, entered into an agreement for sale of land. Defendant number 1, my lord, respondent number 1, in collusion with respondent number 2 and 3, entered into an agreement for sale of land. Thereafter, my lord, in collusion with each other, they have filed a suit for specific performance of contract. My lord, title suit number 99 of 2015. Behind our back, we have not been made parties in that particular suit. Thereafter, my lord, by way of by playing fraud upon the learned court below, my lord, they have filed a joint compromise petition. Your lordship will find, my lord. And on the basis of that petition, my lord, the learned trial judge has passed a decree.
Thereafter,
Absolutely fraud, my lord. Your lordship.
no,
will-
thereafter what
my lord,
happened?
my lord, then, my lord, Annexure 4, page 18 is the order which shows that, my lord, joint petition has been filed, which was allowed. Thereafter, my lord, page 20, your lordship will find, my lord, order dated 27/9/23, prepare a decree. These all are in collusion, my lord, and behind our back.
Thereafter what
Now,
happened?
Annexure 5, your lordship will find decree, compromise decree. Now, this decree was put into execution, my lord. Title execution number 16 of 2024. My lord, Annexure 6, page 24 may kindly be seen. Decree holder is represented, service report.
Okay, now
of-
thereafter what happened?
My lord, thereafter, my lord, sale deed was executed by the learned court below.
Okay,
Annexure 7, page 25.
thereafter,
Then, my lord, page 40, Annexure 9 may kindly be seen, the order dated 9/8/2024. Last paragraph, my lord, page 40. Heard and perused, considering all aspects of the decree holder is allowed and directed to take steps for issuance of writ of delivery of possession. Now, my lord, sale deed is executed behind our back, and they prayed before the court for delivery of possession. Thereafter, writ was issued. No, thereafter, your lordship kindly see, my lord, annexure 10, page 41. Nazir went there, Nazir submitted a report that police help is required. Page 41, my lord, order dated
Yes,
25.
thereafter what happened?
Yes. Thereafter, my lord, on page 11, my lord, page annexure 11, page 41, my lord. Decree holder is represented, submitted challan of police cost.
Thereafter what happened?
Thereafter, my lord, yes, interesting, my lord.
To come.
Thereafter, we filed an application under order 21, rule 101, 105 before the learned executing court for, my lord, adjudication of the right, possession and interest of,
Where is your petition?
yes, that petition, my lord. My lord, it is reflected in the order, but we have annexed it? We have not annexed it.
What happened on your petition?
Yes, my lord, that petition has not adjudicated upon. That is,
Where
that
is the,
only grievance. my lord.
where is the order?
Well, that order your lordship will find. But thereafter what happened? We preferred an appeal against
No,
this
before
order.
appeal, you show me the order passed by the executing court. Where is the order of the executing court?
Executing court order, my lord, your lordship will find. Page. Order to page 1. My lord, annexure 11, page 41A. My lord, the first part of the order was under challenge before the learned appellate court, first appellate court.
Hmm.
My lord, will take a break.
No, no.
No. My lord, first part of order we have challenged by filing an appeal. And by filing an appeal, we says, my lord,
No, where is the order on your order 21 rule?
my lord, last part of the order dated 8/1/2025. Last part of the, has your lordship got it, my lord? Seen the petition number 224/25 filed by the petitioner under order 21, rule 101, 105, reduced section 151 of CPC. Considering the nature of the petition, means the case number so and so is registered.
Okay, what
Now, my lord, the learned executive court ought to have, my lord, kept in abeyance the main execution
No, what was
proceeding and
your-
to adjudicate this application, my lord, to determine our right
No,
over
we
the
don't know
property.
what happened.
My lord, thereafter, the court issued, my lord, a writ of possession.
No, when your
Thereafter, we filed appeal, my lord. Next page.
appeal
annexure-
against this order.
My lord, annexure 12, page 42. Against that order, my lord, 8/1/2024, 2025. First part of the order, 8/1/2025. Now, my lord, appellate court say that because of pecuniary jurisdiction, we have no power to adjudicate the matter, and thereby, my lord, return the memo of appeal. The appellate court order, your lordship will find, my lord, at page 67, annexure 13. Page 67, my lord, is the appellate court order. The learned appellate court, my lord, call for the record. Paragraph number 13, paragraph number 3, your lordship will find, upon admission of the appeal of for hearing, the original case record of title case execution case number 16 of 2024 was called for and received. Thereafter, my lord, by that order, your lordship will find at page.
Just a minute, just a minute. Okay, where is the appellate court order?
My lord.
Where is the appellate court's order?
Yes, appellate's court order, my lord, page 67 and extra 13. Page 67, my lord. Both the parties are represented. Has your lordship got it, my lord? The Miss appeal has arisen out of Miss case number so against the impugned order dated 8/1/2025, passed by the learned civil judge so in title execution Miss case number in title Miss case number was not adjudicated, which consequently allowed the writ proceeding of attachment. Upon admission of the appeal of hearing, the original case record of title execution case number 16 of 2024 was called for and received. Against the said order, the petitioner praying for a stay of the execution proceeding till the adjudication of Ms. J case number 24 of 2025 in execution case number 16 of 2024, of which the writ of proceeding for disposition of the petitioner's appellant was issued simultaneously, and the civil Nazir were under the direction to immediately execute the same by disposing the petitioner appellant. Since if the execution proceedings are not stayed, the same would gravely prejudice the petitioners whose entire contention is adverse possession, would render it onerous. Upon pleadings of the parties, the learned trial court had decreed the suit in favor of the respondent number 1, being aggrieved and dissatisfied with the order dated so and consequent issuance of writ dated so, pursuant to the orders passed by the learned civil judge, senior division number so. This appeal is preferred on the following ground. Now, these are the grounds, my lord. 1, 2,
No,
3.
no, these are not necessary.
These are not necessary, my lord. And ultimately, my lord, the learned appellate court said, my lord, paragraph number 9, my lord, at page 71. In view of the above discussion, has your lordship got it, my lord? In view of the above discussion, the present appeal is without jurisdiction. As such, the memo of appeal is returned to the appellant to be filed before the proper forum. Now, our suit is valued, my lord, at rupees 30 lakhs. And as per the notification, my lord, the pecuniary jurisdiction of the learned district judge is 20 lakhs. Now, for lack of jurisdiction, my lord.
Now, which order you are impugning?
My lord, my impugned order is order dated 22/5/2026 at page 72, annexure 14. My lord, after returning of memo of appeal to us, when we preferred, my lord, an appeal before this honorable court, my lord, FAO, my lord, we have filed it before this honorable court. By this time, my lord, they have filed an application for restoration of the execution case. The learned executing court, my lord,
FAO
restored,
is still pending.
my lord.
FAO is pending.
FAO we have filed, but the coordinate bench of this honorable court said, my lord, instead of filing FAO, we should file revision petition. That's why, my lord, we have withdrawn and filed this revision. My lord, this is the order. Because, my lord, the court said, my lord, learned coordinate bench said, my lord, the application that we have filed under order 21 rule 105 has not been disposed of.
Yes, rightly said.
Rightly said. I was also my lord, agreed with the opinion by the learned coordinate bench. My lord. That's why we withdrawn yesterday and filed, my lord, yesterday itself, my lord, this civil division petition, and my lord, and accordingly this case. My lord. Now our grievance is, my lord, pendency of this FAO and, my lord, this civil division petition, my lord, that we have filed, my lord. Your lordship kindly see, my lord, next page, page 15. Page 15 is the writ of possession bill.
So this date has, when is the next date?
19/6/2026, my lord. At the top, your lordship will find right hand side. 19/6/2026 is the next date fixed for report. Now, my lord, they all said with bulldozer, police personnel, paramilitary forces, my lord, with laborers, masons, my lord, to demolish our, my lord, residential house where we have been residing for last.
Where is your
years.
petition under order 21 rule?
That petition, of course, my lord, it is reflected in the order, my lord, but we have not annexed it. We did not, my lord, that your lordship may call for the record, my lord, your lordship may examine,
No.
my lord. Oh, my lord,
That
with
is the
regard to
basis.
veracity.
Your case is based on that petition.
Correct.
That petition is not adjudicated and you have not annexed that petition.
But it is reflected in the order. I have
But
shown
we
your
don't
lordship.
know the contents. What
Yes,
you
my
have.
Yes, my lord. That is, of course, there, my lord. We say, my lord, that the same thing that we are riot, Khatian has been issued in our favor. So we have got the.
Where is that?
Yes, my lord, that is, my lord. 24 petition from court. Why not? This is the application. I'm sorry, my lord, I could not annex it because it was filed hurriedly, my lord, yesterday itself. That's why, my lord, it was skipped. This is the application we have filed.
You bring this on record.
Bring, my lord, till then, my lord, some protection, my lord, they are all set, my lord, to demolish my residential house. My lord, your lordship has seen, my lord, the order itself says, my lord, reveals that this application has been filed.
Mr. B.K. Sen, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners. How many petitioners are there?
3 petitioners.
By the petitioners. Impugning the order dated 22/5/2026 passed by the Court of Learned Civil Judge Senior Division number 1 in title execution case number 16/2024, whereby without adjudicating upon the application filed by the present petitioners under Order 21 Rule 101/105 of the Code of Civil Procedure, the writ has been issued and the where is your 151 petition which was dismissed?
Along with the, along with that application, we have paid for stay of the execution.
No, this 22/5/2026 has, who filed the 151 petition?
No, they filed it for restoration of execution case. After, my lord, the appellate court passed the order returning memo of appeal.
मोहम्मद क्या लिखा? No, not that. ये तो काटो. Where is the order of issuance of writ? After this has been restored, there is nothing to indicate.
Yes, my lord, this order 22/5/2026.
Yes, where?
In view of the order, last paragraph. In view of the order passed in Miss Appeal number 2 of 25, the instant execution case is restored. The decree holder is to take steps
For what?
for possession. Decree holder is to take the application that has been filed by them for restoration is disposed of, and this is for report. Then, my lord, writ of possession.
And the application under section 151 of the CPC filed by the decree holder has been allowed, and the execution case number 116/2024 has been restored, and the decree holder were directed to take steps for issuance of writ, and 19/6/2026 was fixed for report. Learned counsel for the petitioner submits that the petitioners are the predecessor in interest of the petitioner, where the riot in respect of the decretal land and were in possession of the same since last more than 50 years. He further submits that the decree of which the execution is sought for in title execution number 16/2024 has been collusively obtained by the respondent number 1, 2, and 3. 1, 2, and 3. 1, 2, and 3. And after coming to know about the pendency of the execution case, the petitioners filed an application under Order 21 Rule 101/105, read with Section 151 of the Code of Civil Procedure. However, he further submits that though on the basis of the said petition, Ms. J case number 24/2025 was registered. However, without adjudicating upon the petition filed by the present petitioners under the present petitioners, the execution case has been proceeded with. He submits that an application filed under the aforesaid provisions before the executing court has to be decided first before issuance of writ for execution of the decree obtained by the respondent number. Who obtained the decree? Who is the decree?
Respondent number.
Respondent number 1. Hence, agreed with the restoration order dated, agreed with the order dated 22/5/2026, whereby the title execution case number 16/24 was restored and writ has been issued. The petitioners have approached this. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, within 3 days from the date of this order, returnable on 31st July. Stop. In the meanwhile, considering the submissions made by the learned counsel for the appellants, as discussed in the foregoing paragraphs, as well as considering the materials on record, till next returnable date, the further proceeding of title execution case number 16/2024 is hereby stayed.
Pending in the Court of Senior Division number 1, Kamrup Metro, Gauhati.
Title execution case number so pending in the court of Learned Civil Judge Senior Division number 1, Kamrup, Gauhati shall remain stayed. List accordingly.
I am deeply obliged, highly obliged.
Take any other act. And this supply list item number 18. I have come to know that by 3 o'clock in the evening, my lord, the withdrawal application will be made available. So let it be taken tomorrow, my lord.
Other side,
Yes, he has given consent.
okay. 18, item number 18, instead of Monday, it will be listed tomorrow,
Obliged.
19.
I'm obliged.
Item 2.
May I please, your worship? The respondent is plaintiff, file a suit for right title, interest and confirmation of possession. And present petitioner defendant, he filed the written statement. But during pendency of the suit, the defendant was dispossessed. Then a petition was filed under Order 8 Rule 9 for additional written statement with counterclaim for recovery of possession. That petition has been rejected. Against that order, I prefer this revision.
Okay, where is that order, impugned order?
That is page 36, Annexure 6.
Yes,
Well, may I read?
yes.
Both sides are represented. The case is for order today. On 22/3/2024, the defendant number 1A to 1C2A had filed a petition number so-and-so under Order 8 Rule 9 stating that during pendency of the suit, defendants were illegally disposed on by the plaintiffs therefore, although they were in continuous possession thereof on strength of a registered sale deed 6248 of 66. The plaintiffs have objected to the aforesaid petition stating that plaintiffs have filed a suit seeking declaration of right title interest along with confirmation of possession. The defendants had been continually disturbing the plaintiff's possessions prior to institution of the suit. The plaintiffs had also filed a petition seeking injunction restraining the defendants from disturbing their peaceful possession, and the same was registered as so-and-so. The petition was allowed by a order dated so-and-so. It is submitted that this makes crystal clear that the defendants have falsely alleged that they were dispossessed from the suit land on 11/5/2022. I have gone through the order dated so-and-so, whereby temporary injunction was granted, taking into consideration the fact that one of the reliefs sought by the plaintiffs in the plaint was confirmation of possession. Having gone through the plaint, I find that the same was filed on 3/1/2022. The defendant number 1A to 1C2A had filed WS on 4/4/2022, denying the claim of the plaintiffs and submitting that this is they who are in possession of the suit land. But strangely, my lord, that is true. They did not seek any relief of confirmation of possession at that time by filing any counterclaim. This is the my lord findings. Thus, in my considered opinion, no counterclaim can be undertaken. At this juncture, seeking a fresh relief of recovery of past possession, alleging disposition on 11/5/2020. More so considering the fact that trial has already commenced upon framing the issue and evidence on affidavits of plaintiffs have already been furnished. Petition number is rejected. The findings of the my lord.
No, read para 6 again.
My lord.
Once.
I am also confused. Having gone through the plaint and find that same was filed on so-and-so, the defendant number 1A, 1C and 2A had filed WS on 4/4/2022.
Who are you?
I am the defendant.
Number?
Defendants
All defendants.
denying the
Why
claim.
this 1A, 1C? They are
But
legal heirs.
legal.
How many defendants are there?
4.
4. Okay. You are representing all 4.
My lord.
Denying the claims. Please read.
My lord. Denying the claims of the plaintiff and submitting that it is they who are in possession of the suit land, but strangely, they did not seek any relief of confirmation of possession at that time by filing any counterclaim. Why I will claim a counterclaim for confirmation of possession, my lord. When I was dispossessed, then I have filed petition for recovery of possession that
Yes.
thus in my consider no counterclaim can be attacked.
Yes. Here in the plaint,
No, just
here are about
a minute. You have anything else to submit?
My lord, I am relying on judgment. That is, of course, there is delay in filing the instant petition for, my lord, Order 8 Rule 9. Honorable Supreme Court says delay is not the, my lord, important, but if the defenders are not prejudiced, amending the written statement order 8 Rule 9, then no, it can be considered. para 7,
Which para?
para 7. my lord. Thank you.
Which lines your?
My lord, your lordships kindly last paragraph,
Para 7.
para 7. Last, like it, as noted here earlier, by filing an additional counter statement in the present case, in our view, would not cause injustice or prejudice to the respondents, but that would help the court to decide a real controversy between the parties. In our view, the High Court was therefore not justified in rejecting the application for permission to file additional counter statement, as no prejudice could be caused to the respondent, which would otherwise be compensated in terms of cost.
When you have alleged, when you were dispossessed,
Mine.
1/5/20, 11/5.
11/5/23.
When have you filed the,
On 22/3/24, there is delay, of course. Sir.
so much delay after
My last
dispossession?
after eight months or that. That's Supreme Court said belated application can also be considered by compensating the respondents. My lord. Unless they are prejudiced, unless they are
And what stage the trial is pending?
minor.
At what stage the trial is pending?
My lord, now it is evidence of
Of,
PW's cross.
so they have already
Filed
Uh,
affidavit.
affidavit.
That stage.
So if your petition is allowed, they will have to again file a affidavit.
Written statement, oh, sorry, my lord, against the counterclaim, they will get the scope to file an
Additional written
additional written state. That is
The suit will again go back.
one state, my lord. Only one state.
Yes,
That is correct.
yes,
Yes.
Mr.
May I,
Lord.
Lordship? May I take your lordship to the page 32, lordship, of that petition, lordship? In their petition, the original suit was against 12 defendants. It was contested by only 4. Others did not contest the source. The petition was filed by 4. And their prayer portion, lordship. It is therefore prayed that Your Honor will be pleased to allow the petition granting leave to defendant to file counterclaim. This is a petition under Order 8, Rule 9. They have prayed before the court for having a leave to file counterclaim in the above mentioned suit to avoid multiplicity of proceedings and for the purpose of proper adjudication of the suit. This is only there. In the impugned order, lordship, trial court has rightly mentioned that suit was filed on 3/1/2022. They have given 4/4/2022. May I draw your kind attention to lordship, Order 8, Rule 6A. When a counterclaim can be filed.
Yes,
6A. May I read, lordship?
yes.
A defendant in a suit may, in addition to this, his right of pleadings, a set of under Rule 6, set up by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action. This is important here, lordship. Of a cause of action accruing to the defendant against the plaintiff, either before or after filing of the suit, but before the defendant has delivered their defense, or before the time limit for delivering their defense has expired. Here, lordship, 6A provides that a counterclaim cannot be filed for a cause of action accrued after filing of the WS. It has to be filed either before filing of the suit or up to the level, the date of filing of the counterclaim or WS actually filed. Here in this case, admittedly, they have filed their defense on 2020 2 Lordship itself. Code 2022, they have filed their WS. Their cause of action, if assuming true, then also erosion 11/5/2023. It
After
cannot be brought in the form of a counterclaim.
they have to file a fresh suit.
They have to file a fresh suit. They have that. I'm not denying that they have a right. Here in this case, interestingly, there is an injunction in my favor, restraining them not to dispose it. Thereafter, they have that brought the plea, let them. 6A, do not permit them to file any counterclaim for a cause of action which arose after filing of the WS. Secondly, Lordship, they have filed a leave along with the leave petition as decided by our Honorable High Court. They have to mean what type of additional pleading they want to file. They have not annexed in this petition, and to my instructions, they have not filed even before the trial court. What additional pleading they want to move there? Learned trial court, though, has not taken care of 6A, but their counterclaim is not maintainable. I'm like to relying on a judgment, Lordship, the 3 judge judgment on Supreme Court of India, Lordship, Ashok Kumar Kalra, exactly on this point, Lordship. Order 8, Rule 9. In this case, Lordship, it has been clearly decided. After framing of issues, a counterclaim 8-9 may be permissible, but not after framing of issues. In our case, when they have filed it, already we have submitted our evidence, and on that day, case was fixed for cross-examination.
In para?
Lordship, I am giving the progress chart, Lordship.
No. In the judgment which you have cited,
Lordship,
which
just a minute. Lordship, Para 19, Lord. Para 16, Lordship, the limitation for filing the counterclaim is not explicitly provided by the legislature, rather only limitation as to the accrual of the cause of action. It is in para 6. Lordship, this judgment is in 2 parts, Lordship. One by majority part, other by honorable single judge, concurring judgment. Para 16 of the first part, Lordship. A judgment to be this para 16, Lordship, it also repeats the cause of action. Accrual of cause of action is the time limit, Lordship. And in para 19, the ultimate findings. So this petition is otherwise not maintainable, Lordship, because the learned trial court has rightly rejected the petition. They have the right to file a fresh suit, no problem.
any reply?
Only to avoid the multiplicity of the suit, but this.
No, what about the bar?
That is
Bar provided in 6A.
8-6, that is correct. But our cause of action arose on 11/5/2023.
Yeah,
Because subsequently, we have been dispossessed.
it cannot be subsequent to 90 days. That is the period for you to file written statement. The cause of action must accrue before lapse of that 90 days.
Before filing WS, last limit is WS, before submitting that WS.
Yes.
We may be allowed to file this fresh suit that.
Heard Mr. N. Hawk, the learned counsel for the petitioner. Also heard Mr. S.K. Poddar, the learned counsel for
Both the response.
both the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 12/3/2025 passed by the Court of Learned Civil Justice Junior Division number 1 Borpeta in connection with title suit number 2/2022, whereby the application filed by the present petitioners under Order 8, Rule 9 of the Code of Civil Procedure 1908, seeking leave to file counterclaim, was rejected by the trial court. Learned Mr. N. Hawk, the learned counsel for the petitioner, has submitted that the present respondents had filed a title suit against the present petitioners seeking relief of declaration of right title and interest and confirmation of possession over the suit land. In the said suit, the present petitioners had filed their written statement on 4/4/2022. However, during the pendency of the said suit on 11/5/2023, the present petitioners claimed that they were dispossessed from the suit land, and as such, they filed an application for filing an additional written statement as well as counterclaim under Order 8, Rule 9 of the Code of Civil Procedure, which was rejected by the impugned order. Learned counsel for the petitioners submits that the reasoning by the trial court for rejecting the prayer of the petitioners is not appropriate, as it has observed that if before 11/5/2023 the present petitioners were in possession of the suit land, they could have very well filed a counterclaim seeking relief of confirmation of possession. He submits that same was not necessary, as the petitioners were already in possession and they were dispossessed only on 11/5/2023. He further submits that while dismissing the petition under Order 8, Rule 9 of the CPC filed by the present petitioner, the trial court also did not consider the fact that the dismissal of leave to file counterclaim would only result in multiplicity of suits, as the petitioners now may as in event of not allowing the petitioners to file counterclaim, they have to file a fresh suit, which he submits that the apex court has deprecated the practice of not avoiding the occasions which would give rise to multiplicity of suits. In support of his submissions, he has cited a ruling of the Apex Court in the case of Olympic Industries versus Mullah Hussaini Bhai Mullah Akbar Ali and others, reported in 2009 AIR AC 2029. On the other hand, Mr. S.K. Poddar, yes. On the other hand, Mr. S.K. Poddar, the learned counsel for the respondents, has submitted that the trial court has rightly rejected the prayer for grant of leave to file counterclaim at a belated stage. He submits that the statutory provisions contained in Orders 8, Rule 6A bars filing of a counterclaim in respect of any cause of action accruing to the defendant against the plaintiff after the defendants have delivered defense or before the time limited for delivery of defense has expired. He submits that in the instant case, the application under Order 8, Rule 9 seeking leave of the court was filed by the present petitioners much after submission of their written statement by the present petitioners. He submits that in fact the suit is at the stage of evidence of plaintiff's witnesses, and the plaintiffs have already submitted their evidence on affidavit before the trial court. He further submits that, moreover, in an application under Order 8, Rule 9 of the Code of Civil Procedure, the applicant had to specify no. No, in support of his submission, the learned counsel for the respondents has cited following rulings. Ashok Kumar Kalra versus Wing Commander Surendra Agnihotri and others, reported in 2020 within bracket Takibo 2 HCC 394 number 2. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. though the reasoning by the trial court in disallowing the application under Order 8 Rule 9 of the Code of Civil Procedure filed by the present petitioner, that is, if the petitioners were in possession of the suit land, they could have sought relief of confirmation of possession at the time of filing their written statement. May not be very sound reasoning. However, in the facts and circumstances of this case, the embargo contained in Order 8, Rule 6A regarding the limitation within which a counterclaim may be filed by a defendant is squarely applicable to this case. It appears that the written statement that the present petitioners filed their written statement on 4/4/2022 in the title suit number 2/2022, denying the contentions of the respondents. And it is after more than 1 year from that date, that is on 11/5/2023, the petitioners are claiming to have been dispossessed from the suit land. As such, it is a clear case where the cause of action accruing to the present petitioners against the respondent has arisen after filing of the written statement by the present petitioner or before the time limit for delivering of the defense has expired. And as such, a counterclaim is barred by limitations provided under Order 8, Rule 6A within bracket 1 of the Code of Civil Procedure. The defendant, the present petitioner, may, however, bring a fresh suit for the said cause of action, provided same is subject to the law of limitations. With above observation, this civil revision petition is dismissed.
Disposed.
Disposed of.
Applies.
Court hearing under order 41/20.
Yes, Mr. Shah.
May I please rush?
Yes.
My lord, before I going to the case, my lord, I want to make a clarification before your lordship regarding the shoot land. Where from the shoot land has come, my lord. Your lordship, would be pleased to turn to page 64B.
64.
64B. Here your lordship would be pleased to see in the top, my lord, Hator Akshona Jawabundir Nokol. Now your lordship, here one Korondor, serial number 1. On Korondor with the original Patatan. Thereafter, my lord, Muhammad Latif, Rafikuddin, Kormot Uddin, Zomiruddin. My lord, serial number 5, Zomiruddin is relevant, my lord, your lordship will think, and Abu Shama. All are sons of Korondor. So after death of original Patadar, my lord, this 5 person has come. Latif, Rafiq, Kormotuddin, Zomiruddin, and Abu Shama, the Korondor.
How much is the land?
My lord.
How much is the land?
My lord, the land is here, it is shown in 3 bighas, my lord. And in the shoot, in concerned shoot, my lord, it is shown as 2 bigha, 3 katha, 1 lesson. So, my lord, this is the land. Now, your lordship, lastly, your lordship will come to 12. Wazuddin. Wazuddin is son of Rajab Ali. So, my lord, your lordship would be pleased to see he has no connection with original Bhattadar. Now, your lordship would be pleased to see right hand column, my lord, in Ko. সরজমিন সিটার তাবুত দিয়া চক্রবিষয়া মহোদয়ৰ 1903 তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে সিটাৰ তাবুত দাগৰ লেচা মাটিত 1 নং কৰন্দৰৰ স্থলত. Now your lordship will get লতিফ, রফিক, কর্মত, then জমিরুদ্দিন, then আবু শামা নামে নামজারি হয়. So Korondor's land has come to this, his 5 sons. Now your lordship, খ চক্রবিষয়ার সরজমিন সিটাত এত তারিখর হুকুম মতে উত্তরাধিকারী সূত্রের পাট্টার 258 দাগে 6 নং পাট্টাদারর স্থলত মোহাম্মদ Ali Hizbi. Ali Hizbi, my lord, is appellant number 2 before your lordship. Ali Hizbi name namjari hoy. So, my lord, in place of Zomiruddin, Zomiruddin, my lord, in place of serial number 5, Ali Hizbi, appellant number 1 recorded. Now, your lordship, it is important, Go.
Yes.
My lord, 6-7-8 নং পাত্তাদাৰৰ স্থলত মোহাম্মদ আবু শামা পিতা করন্দৰৰ নামে নামজারি হয়. ওই তারিখৰ হুকুম মতে অংশ সূত্ৰে আবু শামাৰ স্থলত 258 দাগে মোহাম্মদ ওয়াজুদ্দিনৰ নামজারি হয়. Now my question before your lordship, how Abu Shama will get here? Abu Shama is not there.
Who is Abu Sama?
Abu Shama is son of my lord
Karmati.
Korondor, serial number 6, my lord.
Okay.
So
And
in
Abu
case of
Sama
Abu Shama,
sold the land to Wazuddin.
my lord. No, my lord, he did not sold. Here, what happened? It is not said by purchase. অংশ সূত্রে অংশ স্থলত 1 নং স্থলে ওয়াজুদ্দিনের পিতা রাজঙ্গীর নামে নামজারি হয়.
He must be some relative. He may be
অংশ সূত্রে.
relative of.
My lord, your lordship would be pleased to note that অংশ সূত্রে. Onkohutre, my lord, my humble submission before your lordship, he cannot get share of the land because he is from other side, my lord, that his father name is Rajabali. He not said that I have purchased. He not said it is gifted. Not said that there is exchange. So, my lord, he is to give the land by transfer, either by gift.
Now, who is Rajabali? Who is Wazuddin?
Wazuddin is outsider, my lord. Wazuddin is the plaintiff.
Wazuddin, in his paper,
Wazuddin is
decree
the
has
plaintiff.
been.
He filed a suit. That is the connected suit.
But that will be decided in the suit.
My lord.
On what basis Wazuddin
My lord,
plaint has.
that is my question, my lord. In the suit, my lord, that is not at all decided.
We'll
That
discuss
where from Wazuddin has got the land. Now your lordship would be pleased to.
at two.
My lord.
At two.
Oblige lordship.
Yes.
Lordship allow, I am making small variance, item number 8. Adjournment petition, adjournment variance.
Who is for the other side? You have objection?
All of them today, just he called me some time ago, but his senior is sick.
Okay. Heard, Mr. What is your name?
And Thakuria for S.
N. Thakuria, appearing for,
All left, airplane.
appearing, N. Thakuria, item number 8.
8 was.
N. Thakuria prays for an adjournment on the ground of ailment of the conducting counsel for the appellant. Mr. S.R. Gogoi, considering the grounds shown, does not learned counsel for the Mr. S.R. Gogoi, learned counsel for the respondent.
1 to 5.
1 to 5, comma, considering the grounds shown by the counsel for the appellant does not raise any objection, hence the prayer is allowed. Let this matter be listed 3rd of September.
Hello?
September.
Pass all us.
Lordship, with the consent of other side, I'd like to mention item number 16, Lordship. Lordship, in item number 16, I am seeking an adjournment on the ground that the conducting counsel, due to some uneasiness, has left the court, Lordship.
Heard, Mr.
S.A. Singh, Lordship.
S.
S.A. Singh, Lordship, for the
S.
appellant.
Singh, appearing for the appellant. Also heard, Mr.
On behalf of Arshik.
What is your name?
K. Borba.
K. Burman. Appearing on behalf of Mr. R. Shekhar. Learned counsel for the appellant seeks an adjournment on the ground that conducting counsel for the appellant is not feeling well. The prayer is allowed. Let this matter be listed. 10 September.
Can it be August? Obliged, Lordship. Highly obliged.
Yes, Mr. Rathi, anything? You have anything to say?
I got confused.
When you want to mention something?
No,
Okay. Yes. Now, what is your case?
Well, now your lordship, thereafter what happened, my lord, your lordship would be pleased to see, again I am referring to 64B, my lord. My lord, in tag number column, my lord, 99. Tag number column 99
Yes.
and 258. 258 is relevant here, my lord. Now your lordship, do please to go to page 63, my lord.
Yes.
So, my lord, what I have pointed out, that this Wazuddin does not have any share in the land, but his name is recorded as Onkho. But he cannot get share because he is outsider. Now your lordship will please to see. Now he deposited some premium. Premium against the land, my lord, that Tarikhor Hukum mote in the right hand column, my lord. Zilar Upayukto Mohodayor 2/55 নম্বর 2/2005 নম্বর মেদি গছৰৰ ওপৰত দিয়া এত 2005 তাৰিখৰ হুকুম মতে 33 নং একশনা পাট্টাৰ 258 নম্বৰ দাগ। So, my lord, this land premium for which is deposited is belong to dag number 258, my lord. So this is the same land. 258 দাগর অঙ্ক 3 কাঠা 17 লেসা মাটি চালান
This
যোগে
258, what is the patta number?
258, my lord.
Dag number is 250.
Patta number 33, my lord. That is not reflected in the Zomabundi there, my lord. That is photocopy only. But it is clear that that is 33, Akshona Patta. And your lordship would be pleased, 3 nong Akshona Patta. What I refer to 64B, my lord, that is Akshona Patta. And that number is 158.
Where is the indication that it is Aksana patta? Annual patta.
Annual patta, my lord.
Where is the indication?
64B, my lord.
Show me where it has been. Only dag number is indicated.
64B, my lord. Hator Akshona Jawabandi Nokol. In the top, my lord. But this patta number is not highlighted here, my lord. It is not in the photocopy. But this is the land. Because that number is 258. So, my lord. Now, your lordship, 33 নম্বর একশোনা পাট্টার 258 দাগর অঙ্ক 3 কাঠা 17 লেসা মাটি চালান যোগে এত টাকা প্রিমিয়াম জমা দিয়াত 192 নং মেদিত জমা করা হয়, এত সনদ দোলভুক্ত হয়। Now what happened, my lord? After doing this, first he entered his name as sharer without having any source how he is sharer. And thereafter, my lord, what happened? He converted the land, annual patta land, into his name, giving premium, and recorded his name as Medipatta. Metipatta. Now your lordship will be turned to page 21. my lord. His plaint, my lord. Page 21. So, my lord, first I pointed out to your lordship Wazuddin, plaintiff, versus Akbar Ali. They are also outsider person, my lord. They are not Patadar. And we are the Patadar, my lord. We were not made party here. He made some persons, Akbar Ali, etc. 5 persons. Now, what is his suit, my lord? Suit for declaration of plaintiff's right, title, and interest, and recovery of cash possession. A plot of land measuring 3 kata 17 lesa covered by dag number so and so is the subject matter of the suit, my lord. We can skip it. Now your lordship will see the para 2, page 22. That as per Jomabandi copy of the suit patta issued for the year 1974-75, it appeared that the shoot land measuring 3 kata 70 lesa originally was annual patta, and same was converted to periodic patta by it conversion case number 2/05, White order dated 2605, as appears from Jomabandi copy note co, as I referred, my lord. The shoot PP number 192 coming from annual patta 33 and dag number 258. After conversion to periodic patta, 3 dag number was changed into new dag number 483. That the plaintiff is the owner. Now your lordship will consider the plaintiff is the owner. How he is owner, my lord? That is not mentioned. Now, subsequently, my lord, he said that these defendants was in the land. I have given permission to occupy the land, but they are not vacating the land. That is why the suit is filed. That is the contention. And thereafter, my lord, we are not party. These people, my lord,
In whose possession land is?
My lord,
In whose?
land is in our possession, my lord. The land, shoot land is in our possession. But he shown somebody else that they are in possession. So they did not contest. These people, my lord, if they were in possession, they got notice, they did not contest because they are sure that we are not in the land. Now what happened, my lord, your lordship will be pleased to see judgment passed by the Munshi, my lord. That is Civil Judge Junior Division, page 26, my lord.
Yes.
Now, your lordship, the facts is stated like this, that they are not giving possession to the plaintiff. Now, your lordship will come to page 30. To the case of the plaintiff, defendant appeared, para 11, but did not file the written statement. Hence, for just decision of the instance case, the following points for determinations were framed. Whether plaintiff has any right, title, and interest over the suit land described in Schedule A, Schedule land of the plaintiff. During the trial, para 12, my lord. During the trial, plaintiff side examined 3 witnesses. It is to be pertinent to mention here that the defendant did not appear at the time of cross-examination period. Point for determination. Now, my lord, on the basis of evidence, my lord, your lordship would be pleased to see page 33, my lord. Para 18. I have perused the Jomabandi of PP number 192 and revenue paying receipt which are exhibited in the instant case. On perusal of Jomabandi copy exhibit 1, of it's found that name of Wazuddin is mutated with respect to the land covered by dag number so-and-so, patta number so-and-so, and the note co of the said Jomabandi, it is mentioned that 3 kata 17 lessa of land was converted in periodic patta on payment of premium. Here, my lord, your lordship pointed out to me that the code below, my lord, will say how he got the land. Nothing has been said. It is said that his name is in the record. On the other hand, perusal of exhibit T, that is the revenue receipt. Hence, the plaintiff has, para 21, my lord, hence plaintiff has right, title, and interest over the scheduled land. So, decree was done accordingly. And thereafter, what happened, my lord? A execution case was started.
Thereafter?
Execution case was started, my lord. Thereafter, we came to know that the decree was there. Then we file a petition under order 21, rule 99, 47. So that petition was dismissed by Munshi.
Where is that order?
My lord. Your Lordship would be pleased to see page 50. That petition, my lord, in title execution case number 8 of 2015, petition was number 39380. The petition was filed by Jinnur Ali, appellant, my lord, and Al Hizbi under order 2199, read section 47 of section 51 CBC, stated that they were the owner and possessor of the land measuring 2 bighas 1 katha 3 elasa covered by dag number 258 AP number 33 situated Hekun. The opposite party Wazuddin, in collusion with revenue staff, mutated his name is AP number 33, what I referred, my lord, already, and also converted 3 katha 17 lesa of periodic patta land by creating new dag 483 PP number 190 without their knowledge. Wazuddin on 18 to 15 obtained a decree in TS number 87 of 13 without impleading petitioner who were co-pattadars of the said land. They came to know the decree when the Najib went to Swan's also. Thereafter, after going through this petition, my lord, without taking any evidence, etc., my lord, the petition was dismissed,
What was the reason?
my lord. A reason has been given that each case has its own merits, and as such, in view of the absence of indication in the order as to under what provision of law the petition was allowed, the aforesaid order of the court in no way influenced the order in this case. Now, my lord, finding is this. Let me also see page 53.
Yes.
They put obstruction during the execution of the decree. Now 54, my lord. Thus, there is no provision of law under which any party mere anticipation of disposition.
What is your submission regarding the observation made by the executing court that order 21, rule 99 can be filed only after disposition? Order 21, rule 99 petition can be filed only if someone is dispossessed in execution of a decree. Before disposition,
My lord, on that point, my lord, before disposition, the point has been decided that I will place the decision, my lord, that nobody will wait for disposition and then file.
you have judgment.
Yes, my lord. I will place before your lordship. Now your lordship, it was dismissed without taking evidence, etc. Thereafter, what happened, my lord? The appellant before your lordship filed title appeal.
Yes.
In the title appeal, my lord, the case was remanded back. And after remand, my lord, again another judgment has been passed. And that judgment, my lord, your lordship, I have already handed over to your lordship with the decision record. That is the order dated 13/12/2024. My lord, first it was petition, and thereafter on remand, my lord, it was registered as Ms. case number 29 of 2019. Lordship can go to page we examine 4 witnesses, my lord. But they did not examine any witness, the plaintiff side. Disposition of what will particular is what it took.
You failed to produce anything in support
My
of.
lord, your lordship, here your lordship would be pleased to see on this point, my lord, my humble submission before your lordship. I examined 4 witnesses, my lord. They were cross-examined. Court is to decide this petition, my lord, as a shoot. Because any order passed here in this petition, my lord, will be treated as a decree. Under section, under rule 101 or 100 like this one. Now, my lord, my humble submission before your lordship. Whether the court below, my lord, that executing court properly dealt with the matter. No issue is framed, my lord, nothing of the sort. So without framing issue, how it will be treated as a decree?
No, if the parties are aware about what is the dispute between them
My lord.
and court deals with that dispute
Here your
without
lordship,
specifically mentioning the issue.
my lord, your lordship would be pleased to see that if whether this trial is proper trial, because we have given 4 witnesses, they cross-examined, they did not turn up and they not filed any witness whatsoever. Now your lordship would be pleased to see their objection. What is their objection against our petition, my lord? In objection also, they did not say that we have got the land by this, that.
No. Whether they are able, you are pressing only on
Hello.
their right.
Hello.
What is your right? That
My right, my lord, I have claimed that it is my predecessor's patta land.
you have
But
not.
thing is this, my lord, only we did not produce this Zomamundi copy. What
Any-
I have referred to your lordship now.
You have not produced anything.
My lord, that is there, my lord. That is the lapse on the part of the petitioner, no doubt. But thing is this, my lord, when I am claiming that we acquired the land from our predecessor. Okay. And they say that we got the patta. How he got the patta, that is to be decided by the court. In the first trial, my lord, it is not done. How the decree will be passed. So, my lord, my humble submission before your lordship, somebody without any source of title, recorded his name, either or way, recorded his name. Is he entitled to get decree of the suit land? Now, my lord, my humble submission before your lordship is this, that he said that it is my patta. How he got the land, that is not there. Now my question before your lordship, that is why, my lord, I have framed the substantial question of law, my
No,
lord.
no, what happened
My lord.
after this?
After this, my lord,
You
after this
preferred
order, I have filed a title suit,
Title,
title appeal.
where is the order?
That appeal was dismissed, my lord. That order is the impugned order, my lord.
Where is that?
Page 7 onwards. Your lordship will go to page 8, para 7. The case of the petitioner's appellant in brief is that the petitioner filed instant case under Order 21, Rule 99, read with Section 47, and 1516 CPC against judgment and order dated 6/2/15 passed in TS number so and so, Morigaon. It is stated that the petitioners are owners and possession of the land measuring.
No, appellate court also dismissed the appeal.
Yes, my lord. Dismissed.
Because you failed to show
Failed to
any.
produce. That is the thing, my lord. That is why, my lord, appellate court, what to have considered, how that petition was considered by the executing court. It is a proper way. And another thing, my lord, when we agitated the matter, my lord, it was the duty of the court to look after the decree also. What type of decree has been obtained? How, my lord, my humble submission before you,
No.
without any source.
Before questioning his right,
He is right, my lord.
you have to
That's all right.
establish your right.
Before questioning his right. But how I am affected, my lord, by a decree? I am affected by a particular decree. Now I can place before your lordship how the decree is obtained without having source of title.
No.
My lord.
In an application under order 99.
My lord. In that case,
Order
my lord,
21 rule 99.
I humbly submit before your lordship. I failed. I did not produce this Zomabundi, nothing of the sort. But the petition under order 21 is not properly dealt with without framing an issue, nothing of the sort. That is not considered by the title appeal also.
Have
That
to
is
take,
also
have
not
to take a
considered.
short break.
My lord.
Have to take a short break.
Your lordship rightly pointed out that I have not produced Zomabundi copy or any document, but orally I have submitted.
No, oral submission is not.
Oral submission will not do. That's all right, my lord. But thing is this, my lord, it is a shoot. Whether shoot is properly decided. And your
You
lordship.
cannot raise that question unless you establish your own right first.
My lord, I by oral evidence I have given.
No.
The document I could not produce, my lord, and your lordship will consider here also another point, that we are the pattadar, and by a decree, my lord, without any source of right, we will be dispossessed from the land. How far it will be justified? Because, my lord, we in the later stage we come to know.
No, if you are the pattadar.
We are co-pattadar. We are co-pattadar. We are not made party.
No, if you are co-pattadar, what prevented you from producing the basis on document on the basis of which you are claiming?
My lord, that is there, my lord. That point, it is difficult on my part to answer. But problem is this, my lord. I am pattadar. I am claiming that I am pattadar, but I could not produce a document. But what document he produced, my lord? That document is not a proper document. That as a whole, my lord, executing court is to look into. That decree has been passed, so it is final. We will not touch it. That is not the thing. In 97, order 21, 97 petition, my lord, the executing court has been given power to look into the entire things, all issues.
Show me.
All issues. That decree has been obtained fraudulently. That is our case. That is to be looked into. Then is to see that where from the source of the title has come. That is to be looked into. And your lordship, here is a decision. It is said that after amendment, my lord, that separate shoot provision has been abolished. Now, my lord, in the decision it is said that his entire thing is to be considered by the executive.
Show me.
No way out, my lord. That is the decision, my lord. Yes.
Which para?
My lord, page 8, my lord. Page 8. in Nuruddin versus Dr. K.L. Anand, 1995, 1 SCC 242, it is held. Para B. Thus, the scheme of the court clearly, the lordship got it.
Yes.
Para B. Thus, the scheme of the court clearly adumbrates that when an application has been made under Order 21, Rule 97, court is enjoined to educate upon the right, title, and interest claimed in the property arising between the parties to a proceeding and between the decree holder and the person claiming independent right, title, or interest in the immovable property, and an order in that behalf be made. The determination shall be conclusive between the parties as if it was a decree subject or right of appeal and not a matter to be agitated by a separate suit. In other words, no other proceedings were allowed to be taken. It has to be remembered that proceeding Civil Procedure Code Amendment Act 1976, preceding 76, right of suit under Order 21, Rule 103 of 1908 Code was available, which has been now taken. By necessary implication, the legislature relegated the parties to an adjudication of right, title, and interest in immovable property under execution, and finality has been accorded to it. Thus, the scheme of court appears to be to put an end to the protraction of execution and to shorten the litigation between the parties and person claiming right, title, and interest in immovable property in execution. So, my lord, decree has been received, but whether the decree is a
No, whether that question can be looked into,
my lord,
whether the decree in favor of the respondent side
Hmm.
is a valid decree or not.
no, that is a question. That is fraudulent decree I have stated in my petition. Now your lordship, what executing court, as per this decision, my lord, matter is open. Now, though decree has been obtained, now the court can relook into the decree. How you get the decree. At that time, we were not before the court. Now we are before the court. The court is to look into where from you got this land. It is to be looked into, my lord.
Heard, Mr. This is item number.
M.A. Sheikh.
Question number, please. Hmm? Nothing from. Heard, Mr. M.A. Sheikh, the learned counsel for the appellant. This I have some urgency. I have to take some short break. Appeal under section 100. This regular second appeal under section 100 of the Code of Civil Procedure has been filed by the appellants impugning the judgment and order dated 4/4/26. Or which is the appellate court's order?
My lord, page 7, my lord.
4/4/26 and decree dated 24/20/26 passed by the Court of Learned Civil Justice Senior Division, Morigaon, in title appeal number 5/2025. Whereby the appeal preferred by the present appellants against the order dated 13/12/2024 passed by the Executing Court of Learned Civil Justice Junior Division number 1 Morigaon in Miss J case number 29/2019 was affirmed, and the application filed by the present appellant under Order 21, Rule 99 of the Code of Civil Procedure 1908 was dismissed. After considering the submissions made by learned counsel for the petitioner, counsel for the appellants, as well as after going through the materials available on record, following substantial question of law is formulated in this appeal. Whether in an application filed under Order 21, Rule 99 of Code of Civil Procedure 1908, the executing court has also to consider the validity of decree in favor of the other side within bracket decree holder if an allegation of collusion has been raised by the petitioner. Your allegation is collusive decree
Collision with staff.
raised by the petitioner. Even though the petitioner had failed to induce any documentary evidence in support of his title in respect of the decretal land. Moreover, when the decretal land under circumstances when the petitioner is claiming possession over the decretal land on the basis of being a joint patadar, issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode. Only Wazatuddin is respondent, or there are other also?
My lord, your lordship will see page 4, my lord, ground number
Okay.
2 and 3, my lord. Can it be taken as substantial The plaintiff can be recorded as a periodic patadar of the suit land without any earlier source of right and title. It's a legal question, my lord.
Number two, whether in an application under order 21 rule 99, the executing court can also go into the question as to whether decree obtained by the decree holder is valid or not, on the ground that it the trial court did not consider the source of the right title and interest of the decree holder in the suit in which the decree has been passed. ये पढ़ दो तो एक बार. Source.
But number 3, my lord, I'm leaving to your lordship whether second one will do, and it is also necessary. Whether mere recording his name in the land record, my lord, plaintiff accrue right over
This is a settled. This is
then it will do, my lord.
issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days, returnable within 3rd of August. List accordingly. You have a IA also.
My lord, I also, my lord. My lord, IA civil 1707 of 2026.
This interlocutory application has been heard Mr. M. Sheikh, learned counsel for the applicant. This interlocutory application has been filed by the applicants under Order 41, Rule 5 of the Code of Civil Procedure, praying for stay of execution.
My
Execution.
lord, my prayer at page 6, my lord. I want stay of this order, impugn order. That will do. Because it is, if it is stayed, my lord, execution will not proceed.
Stay of order, stay of execution of judgment and order dated 4/4/2026 and decree dated 24/2026, which has been impugned in the connected regular second appeal number 59/2026. Learned counsel for the applicant submits that in the connected regular second appeal, the substantial question of law has been formulated and notices have been issued to the respondents. Hence, unless in the meanwhile the execution of the impugn order is not stayed, he would suffer great prejudice. Stop. Issue notice to the other side. Issue notice to the respondents. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August. However, meanwhile, considering the submissions made by learned counsel for the applicant as discussed in the foregoing paragraph. The execution of the impugned judgment and order as well as decree dated 4/4/2026 and 24/2026 respectively passed in title appeal number 5/2025 by the Court of Learned Civil Judge Senior Division Morigao shall remain stayed till next returnable date.
Item 6 and 2, hearing item 7.
Wait, please, Your Lordship. My lord, it's that previous 50 good shade case, my lord. Lordship have heard it, Your Lordship may recall.
Who is the other?
What?
Yes, Devin. Yes. What case?
My lord, the 50 good shade, if Your Lordship may kindly look upon the order dated 11 December 2025.
In this,
Yes, my lord. Lordship has queried upon the respondent railway as to why and as to how the learned tribunal has declared our honorable High Court judgment as per incurium. And the respondents railway were supposed to satisfy in that regard.
11, order dated
11 December 2025, my lord. I'll place that order, my lord. I have the copy.
No, no. I found, you read it, which,
My lord. Para 2, it appears that MFA so and so, MFA 42 2017, a coordinate bench of this court has specifically formulated a question to be answered that whether the railway can levy terminal charges for overloading of for loading of goods in all station. And answer to that said question reflected in paragraph number 10 of the judgment dated so and so, which extracted herein below. Para 10, my lord, I am reading. Regarding the second question, there is no quarrel with the proposition that there are 50 specific stations having all the infrastructure for loading and unloading of goods. And if any of those 50 stations are used, then only railway can impose terminal charge. For other station, railway cannot levy terminal charges. The railway has to refund the terminal charges. This was the observation made by the coordinate bench of our Honorable High Court. Subsequently, para 3, my lord. In view of the above, also having heard the submission of the learned counsel for both the parties, a question was asked by this court that whether it is open for the RCT to take a different view by holding the aforesaid judgment as per incurium. Para 4. Moreover, it also appears that the Union of India had preferred a SLP bearing diary number so and so against the judgment and order dated 9 April 2024 passed in MFA 42. And the said SLP petition was dismissed by the Apex Court while order dated 21st October 2024. Under such circumstances, whether the judgment rendered by the coordinate bench would have a persuasive effect in this appeal. The learned CGC prays for granting her some time to answer the aforesaid queries. My lord, I'll just give a short brief about the fact. Here, my lord, what happens is there is a circular passed by the railway authorities, according to which only 50 stations all over India is having facilities such as crane facilities and other various facilities for loading and unloading of work. Only 50 stations have those facilities. And our Honorable High Court has held that railway can impose terminal charges only in those given 50 stations and in not other stations, my lord. In regard to that, my lord, our Honorable High Court in para 40,
no, what happened in this case?
MFA 42, my lord.
No, what happened in your case?
In my case, my lord, the railway has imposed terminal charges amounting to rupees 15 lakh in the station, which is not falling within those 50 station, my lord. 50 station list as per 5/6/2007 circular, my lord.
Okay. And
that's why I've claimed for terminal charges before the railway claims tribunal.
And in the impugned, where is the impugned order?
Impugned order is at page 23, my lord.
starting from page 23, it's a long, lengthy judgment, my lord.
In respect of many original applications,
Yes, my lord, there are more than,
whether against this order any other appeal has been preferred.
my lord, yes, my lord, there is another appeal been preferred. I am the contending counsel in that matter. In serial number 1 and in serial number 32, my lord. In these two cases, appeal has been preferred, which is pending before the honorable court, my lord.
And this appeal is in regard to serial number.
Serial number 1, my lord, Mahesh Enterprise, leading
And
applicant.
another is,
Serial 32.
what has happened in 32?
My lord, in that case, I preferred a writ petition against the order of the Railway Claims Tribunal. However, during the course of the argument, our Honorable High Court remanded the matter, advised me to prefer an appeal under Section 23 before the Honorable High Court. And that's why, my lord, I withdraw it with a liberty and preferred an appeal. So IA is pending, my lord. In regard to condonation of delay, there was 360 delay since the writ petition was pending. So there is an IA pin pending in that matter.
Okay, where is the observation where the
Per incurium, my lord, I'll
Per
just
incurium.
place that. My lord. My lord, at page 76, my lord, the relevant portion is starting. Para 34.2.13. Page 75, my lord.
75, yes.
If your lordship is here, I may read, my lord.
Yes.
Both these issues came up for consideration before the single bench of the Honorable Gauhati High Court.
What issues?
My lord.
What both these issues?
Both the issue in regard to terminal charges, my lord, 50 stations, 50 goods straight. If my lords may permit, I'll read the previous para.
Yes.
For the context.
Yes.
34.2.11.
34.2.12.
1.2, my lord. The consignment, my lord, it is speaking about the facts, not the issue in hand.
Where is the issue?
Issue in hand is as at para 34.2.11.
Okay. Yes, read.
The above extracts of the relevant Railway Board circular rate circular shows that the Railway Board circular dated 5/6/2007 was not issued by the Director Traffic Rates of the Railway Board, which is solely entrusted to fix, vary, or create freight charges, new charges, but the Executive Director Planning for the Railway Board, who is responsible to chalk out the plan for the development work in Indian Railway. In the above rate circular, though the subject is shown as development of freight terminal, but those 50 stations referred to as goods sheds and not as freight terminal. Further, it stipulates only planning or development upgradation of above 50 goods shed as per the norms given in para 2 of the circular, and which facilities given in para 3 of the circular, for which draft plan was asked for from the General Manager of 16 zonal railways. The Railway Board circular does not give any indication that it relates to terminal charge by any way, but just confined to the development of freight terminal with facilities. In fact, terminal charges along with the development charges was levied for the first time by rate circular dated 29/5/2007 prior to the above Railway Board circular for development and upgradation of facilities on freight terminal. My lord, it is talking about this 5/6/2000 circular, which only. My lords, if I may read para 34.2.13, which is in further paragraphs, it is speaking about 50 good shades, my lord. 34.2.13.
Yes.
Both these issues came up for consideration before the Honorable Single Bench of Honorable Guwahati High Court in MFA 100 2011, Union of India, represented by the General Manager NF Railway Maligaon Guwahati versus Meghalaya Cement, Lohia, so and so forth, order dated 25/6/2015. I'm reading the quoted paragraph, my lord. After careful, which is of our Honorable High Court, after careful perusal of the aforesaid letter dated 5/6/2007, the circular in hand, it does not transpire that before imposing the terminal charges, it is mandatory to have such facilities as desired as per letter dated 5/6/2007. The facilities mentioned in the letter is desirable and not mandatory to hold that the imposing terminal charges, such facilities is required to be complied with. Be it mentioned that prior to issuance of the said letter, Wide Railway Board Circular dated 29/5/2007.
Yes, sorry. Yes.
My lord. My lord, MFA 100 relevant portion I am reading, which was cited by the learned tribunal, my lord.
Yes.
The central government has accorded sanction. My lord, should I read from the starting or should I continue, my lords?
Where are you reading?
Para 12, which is in very small.
Yes, para 12.
Para 12, quoted. After careful perusal of the aforesaid letter dated 5/6/2007, it does not transpire that before imposing the terminal charges, it is mandatory to have such facilities. My lord, MFA 100 is only speaking about facilities. It is not speaking whether 50 good shades or not. Terminal can be imposed as desired as per railway letter dated 5/6/2007. The facilities mentioned in the letter is desirable and not mandatory to hold that the imposing terminal charges such facility is required to be complied with. Be it mentioned that prior to issuance of the said letter, wide rate circular dated so and so, the central government had accorded sanction for levying development charges and terminal charges. Further, it is not in dispute that Changsari terminal shade is owned by the railways, and as in rates, the term all other traffic is included and terminal charges levied on all traffic except container traffic. As such, railway department has rightly levied terminal charges, and the judgment of order dated so and so passed by member technical in claim application number so and so is liable to be set aside. My lord, this MFA 100 is only speaking about the facilities. It is not speaking about whether the railway can impose terminal charges.
But MFA 100 speaks about which terminal?
Apologies.
There are 50 terminal
50
where you can impose terminal charges.
My lord.
In MFA 100, which terminal was involved?
Changsari, my lord. Changsari is falling within the 50 station. 50
Okay.
station, my lord.
So the tribunal held that the judgment.
Our Honorable High Court has held that facilities are not mandatory. MFA 100 is only in regard to facilities, my lord. It is not in regard to stations.
Thereafter, what the tribunal held?
My lord, para 34.2.15, if your lordship may look upon, where the incurium part is starting, my lord.
Yes.
Page 76. We have also gone through the judgment of the emphasis applied, my lord. We have also gone through the judgment of the single bench of the Honorable Gauhati High Court in MFA 42 of 2017, Union of India and two others represented by so and so versus SD Eastern Bhutan, two cases, my lord. In para 10 of the Honorable Judgment, Honorable Single Bench of the court held that regarding the second question, there is no quarrel with the proposition that there are 50 specific stations having all the infrastructures for loading and unloading of goods. And if any of those 50 stations are used, then only railway can charge terminal charges. For other stations, railway cannot levy terminal charges. The railway has to refund the terminal charges. Next para, my lord. From the above referred para, it is clear that the above observation and findings by the Honorable Court was given by finding that there is no quarrel with the upper proposition. Here, no ratio has been laid down with reference to extent circular as given in the previous referred judgment of the single bench of the Honorable Gauhati High Court, which is talking about MFA 100, my lord, which after delving into the contents of the extant Railway Board circular as referred herein above, held that Railway Board Circular dated 5/6/2007 does not transpire that before imposing terminal charge, it is mandatory to have such facilities as desirable as per letter dated 5/6/2007. The facilities mentioned in the letter is desirable and not mandatory to hold that imposing terminal charges. I've just read that paragraph, my lord. It was cited above. After quotation, my lord, thus expressing, if your lordship is there, thus expressing utmost regard to the single bench of the Honorable Gauhati High Court in MFA 42 of 2017, Union of India and two others represented by the General Manager NF Railway Maligaon versus SD Eastern Bhutan Limited, Chhatribadi Guwahati, decided on 9 April 2024. We hold that the above judgment cannot be treated as binding precedent as it is not based on a binding ratio, rather it is based on a proposition about which in that case there was no quarrel. But in cases at hand, there is serious issue in respect to legality and acceptability of the applicant's contention as to the Railway Board Circular dated 5/6/2007 and Railway Circular dated 18/9/2007. And after detailed analysis, which is also
What is 18/9/2007?
18/9/2007, my lord.
5/6/2007 was involved in earlier case also.
In MFA 100, my lord?
Yes.
In MFA 100, 5/6/2007 circular was mentioned, but the case only pertained to whether facilities is mandatory or not. I have that judgment. And after detailed analysis, which is also supported by the judgment of the single bench of the Honorable Gauhati High Court in MFA 100, Union of India represented by the General Manager so and so, we hold that applicant's contention is misconceived and have no substance. Moving further, we notice that MFA 42, if your lordship is here, my lord. Moving
Yes.
further, we notice that MFA 42 2007,
100 lordship.
MFA 100, my lord.
Para 12 onwards.
On the basis of this judgment, MFA 42 and 105 were declared as per increment.
Said that for imposition of terminal charges, lordship, development of specific development is not mandatory of the station.
Yes, yes. I'll come to you.
Lord.
Wait for some time. Yes, yes. Yes, Mr. Ram.
Yes, my lord. Para 34.2.17, my lord.
Yes.
Moving further, we notice that MFA 42 2017, Union of India so and so, it appears that the applicant deliberately desisted to refer the case law. My lord, I am emphasizing on this point, my lord, because I'll just prove that this MFA 100 was duly placed before the single bench. It appears that applicants deliberately desisted to refer the case law on this point contained in MFA 100, Union of India, represented by the General Manager NF Railway versus Meghalaya Cement so and so, which also, next page, my lords, and which also referred by the applicant before this tribunal. In almost all cases, well known above the case law, as it is noticed that before tribunal, Shri K.P. Maheshwari advocate is a lawyer in all the cases and on behalf of the applicant, contesting and arguing the cases. And it is so because there is no reference to MFA 100 in MFA 42. 2017. If the judgment of MFA 100 2011 had been referred in MFA 42 before the Honorable Court, an elaborate judgment on this point in dispute with binding ratio might have arrived at. Now, placing all the respect at our hand to the Honorable Court, it appears to us that rule as per incuriam is fully applicable in respect of the judgment in MFA 42 on the relevance and applicability of Railway Board Circular dated 5/6/2007 to terminal charges. We also pointed out that it is tried that the judgment of the court or judicial forum should be uniform unless it is not overruled by binding precedent. A bench of the same strength of a court or a judicial forum is bound to abide by the previous judgment of a bench of the same strength. And if there is a disagreement, and the matter should be referred to a larger bench of decision. Contrary decision of a court or a judicial forum of the same strength may create uncertainty about the judicial process in the mind of general public. This is the per incuriam portion, my lord.
How the tribunal was wrong.
My lord, I'll just satisfy. At page number 79 also, my lord, there is some relevant portion, if I may read, my lord. Page 79.
Yes.
After the quoted paragraph in italicized form, after that, my lord, if your lordship is there, we found that in last few lines, my lord, last 7 lines, page 70.
Yes.
We found that the applicant had deliberately suppressed to bring the earlier decision of the single bench of the Honorable Gauhati High Court in MFA 100/2011 decided on so and so, and the Honorable Single Bench had no occasion to delve into the applicability of the extant Railway Board Rate Circular in respect of terminal charges. The later judgment being per incuriam as well as not loaded with tangible ratio, but on the proposition without any quarrel. Therefore, we are bound to follow the previous judgment of MFA 100 rather than the later judgment passed in MFA 42, showing great respect to the learned single judge of the Honorable Gauhati High Court in MFA, which decided in MFA 42/2017. Accordingly, Tribunal found nothing in favor of the applicants on the basis of the above decision. Honorable Apex Court in so and so East India of Calcutta, and some judgment, my lord, has been cited, which is not in regard to the terminal.
Okay, whether the judgment in MFA 100 and MFA 42 are contradictory to each other?
No, my lord, absolutely.
How?
I'll just place MFA 100, my lord.
MFA 100 is with me.
My lord.
It is there.
My lord, I'll just read the relevant portion of the MFA 100. MFA 100 was only in regard to facilities, my lord. Whether in those 50 stations, facilities are mandatory or not. However, my case is different. In my case, I'm saying apart from 50
You are
stations,
not within the 50 station.
my case is that MFA 100 is speaking about facilities. I'll just show, my lord, para 3, my lord, the facts, so that lordship may distinguish. The brief facts, if my lord is there, para 3.
Yes.
The brief facts of the case is that the respondent number 1, as the applicant, filed the original application so and so before the learned tribunal, so and so claiming refund of so and so for freight overcharges with cost interest due to imposition of terminal charges at an enhanced rate. The respondent number 1, applicant, booked the train load of so and so under so and so, my lord, emphasis applied, from NTSK CLG under Eastern Railway, Kolkata, to CGS Changsari, my lord. Changsari, the case is different. Changsari is falling within the 50 stations, my lord. Now, my lord, the observation, which was the issue in hand before the Honorable Court in MFA 100, my lord. Para 12 and 13, my lord.
Yes.
From here, observation is starting. After careful perusal of the aforesaid letter dated 5/6/2007 circular, my lord, in my case, it does not transpire that before imposing terminal charges, it is mandatory to have such facilities as desired as per letter dated 5/6/2007. The facilities mentioned in the letter is desirable and not mandatory to hold that for imposing terminal charges, such facilities required to be complied with. Be it mentioned that prior to issuance of the said letter dated 29/5/2007, the central government had accorded sanction for levying development charges and terminal charges. para 13, my lord. Further, it is not in dispute, emphasis applied. Changsari terminal shade is owned by the railway. This is favoring my case, my lord. Changsari is owned by the railways. And as in rate circular dated 18/9/2007, the term all other traffic is included and the terminal charges levied on all traffic except container. As such, the railway department has rightly levied terminal charges and the judgment and order dated 1st July 2011 passed by the learned member technical.
No. What is the meaning of this para?
My lord.
Para 13, what?
Para?
Para 13.
My lord.
What court intends to say? Further read again.
It is not in dispute that Changsari terminal shade is owned by the railways, my lord, falling within the 50 shades as per 5/6/2007.
Where is that? It is within the 50 shade.
My lord, I have annexed the circular, my lord.
Okay.
Page 89, my lord. The circular is starting page 89.
Circular, what is the reference?
My lord, at page number 92, the list of 50 stations are mentioned. Page number 92, part of this circular only. Page 92, my lord, annexure 1 of this circular. If my lord is there.
Yes.
My lord, in this list, zone-wise stations are been mentioned which are notified as terminal stations. Zone-wise, my lord. In the left side, zones are mentioned: Central, Eastern Railway, East Coast, Northern, North Central. So entire India has been covered. Now,
New
my lord,
Jalpaiguri, Guwahati and Changsari.
Changsari, NFR. In NFR, Northeast Frontier Railway, Changsari has been mentioned. That's why terminal charges should have been imposed in MFA 100 because Changsari is falling within 50 stations. The only question which was raised before in MFA 100, my lord, was whether facilities are mandatory or not. Because if your lordship may look upon 5/6/2007 circular, various facilities are been mentioned which has to be provided by the railways. That was the dispute in hand in 5/6/2000 circular, such as all weather approach road, lighting facilities, TMS voice connection, DOT phone and STD facilities, crane facilities, coffee, tea, vending machines, all these facilities, my lord. It was in regard to that.
Why this terminal charge is imposed?
Because of these facilities, my lord. Because there are certain good states which are being developed as terminal stations, my lord, which are developed and has facilities, because of which railways are imposing terminal charges for that purpose.
Under what authority? What provision?
And based on this mere executive circulars, my lord, as per rule, as per section 199, if your lordship may look upon section 199 of the Railway Act, any rule which has to be passed, any rule which is imposed by the railway, it has to be passed from the both house of the parliament. Without getting it passed from the both house of the parliament, railway cannot impose terminal charges based on mere executive circulars.
No, under what provision terminal charges? What rules, regulation, notification?
There is no rule, my lord. I have
Some
also made pleadings in regard to that section 199, if your lordship may look upon.
Some notification is there.
This notification, my lord.
Which one?
The 5/6/2007 circular, my lord.
In the present appeal, this notification is also relevant, na? No, in the present appeal, your goods were from which to which booked from which to which terminal?
My lord. From Jogi Gopa to Hadai.
Jogi Gopa to
Hadai.
where have you mentioned?
My lord.
So neither Jogi Gopa nor
No, my lord, it is not falling in 5650 good shade circular, my lord.
where is 5/6/2007 circular?
Page 89, my lord.
Okay.
My lord, at para 3, if your lordship will
But
look-
this 5/6/2007 circular
Yes.
relates to development of freight terminal.
My lord,
It does not empowers it is not the basis of imposing terminal charges. Is it the basis?
my lord, this
It relates to
development
development
of
of
terminal
freight.
stations. Wood sheds to terminal stations.
Yes, it does not say that only for these 50 included terminal charges may be imposed.
My lord, my lord. If my lords may look upon, I'll read, my lord. The railway board are imposing terminal charges. My lords may look upon annexure 3. Based on circular dated 29 May 2007. I'll read the chronology, my lord. Chronology is very important. Conjoint,
Page number?
page 97, conjoint reading of these two circular, my lord. 5/6/2007 and 29/5/2007, my lord.
90.
97, my lord. 97.
Yes, this relates to
Imposing of terminal
imposing
charge.
of terminal charges. So
Yes, ma'am.
this is relevant.
Now, if my lords may look upon the para 4, para 3, my lord, this terminal charges, these instructions will come in force with effect from 1st July 2007, my lord.
Yes, what it means.
1st July 2007, it will come in force. These issues with the concurrence of Finance Directorate of the Ministry of Railways. Para 4, my lord.
Yes.
Now, if my lords may kindly look upon 5/6/2007 circular. Para 8 of 5/6/2007 circular.
Yes.
Zonal railway should move proposal of development of goods shed and submit the board inclusion of supplementary works program by 30 June 2007. Zonal railway should ensure compliance of the time limit. This
Yes,
issue
but the
is-
fact remains
My lord.
that 5/6/2007 circular is only with regard to the development of terminal.
My lord, because once the development of terminal goods sheds are being developed to terminal station, then only railway can impose terminal charges.
No, from where you are saying so?
Because my lord,
Apart from the judgment,
my lord,
apart from the judgment
my lord,
of this court,
my,
what is the other material on the basis of which you are saying that?
my lord. My lord, because till 30 June 2007, railways were supposed to develop the terminal stations. From 1st July 2007,
So
terminal
after
charges will come
development,
into force.
the terminal charges will come into force.
And only 5/6/2007 circular is in regard to 50 stations, my lord. It's not speaking about other
Yes,
stations.
yes.
Thus, my lord, if the terminal charges are supposed to be levied, then it has to be levied within those 50 stations which are supposed to be developed by the Finance Directorate as per 5/6/2007 circular.
There is,
My lord, my lord, this observation, considering this two circular, the observation of our Honorable High Court in two judgments was made, which has been affirmed by the Supreme Court, my lord. It was Union of India Railway preferred an appeal before the Supreme Court SLP, and the SLP was also dismissed by the three bench of the Honorable Supreme Court, consisting of Chief Justice of India, my lord. I'll just place that judgment order.
this was mentioned in the last order.
My lord. And my lord, I have also applied for certified copy of MFA 42 and 105 appeal. My lord, I'll just place, my lord. Railways have duly taken the plea of MFA 100 before the single bench, my lord. single bench, MFA 100 was duly pleaded before the honorable single bench.
Where in 42?
Yes, my lord, in MFA 42, my lord. I have applied for the copy of certified copy of the appeal, my lord. In para, railway have itself in their appeal. It was the appeal preferred by the railway, my lord.
But the judgment in MFA 42 does not discuss about MFA 100. Makes no discussion about.
My lord, that is there, my lord. MFA 100 is not discussed, but MFA 100 was duly pleaded. It is not necessary to make observation in regard to MFA 100.
Okay,
And
no,
my lord,
now it would be required in view of the dispute which has been raised.
MFA 100 is speaking about only about facilities, my lord. It is not speaking about 50 stations. MFA 42 and 105 is speaking about 50 stations. And my lord, in Honorable Apex Court also,
This 42 has been challenged before the Apex Court.
my lord, and both 105 also, my lord.
And Apex Court has dismissed the SL.
My lord, nowadays in Supreme Court, the website, if your lordship may turn the page, last page, my lord, the similar based on state bench case number judgment date. If my lords will look upon the case number MFA 100 2011 was duly mentioned before the Supreme Court as well.
Where?
In serial number 1 and 2, my lord.
Huh.
MFA 100 was mentioned before the Supreme Court, my lord. This I have extracted from the case status.
No, what it means.
My lord, any similar order or judgment been passed by any high court nowadays, which is similar in nature, has been mentioned before the Supreme Court.
No, it does not speak that it has been mentioned before this. It only
MFA
speaks
it is showing, my lord, though
that
MFA
it
appeal of
involves similar issues decided by any other high court.
any other terminal in regard to terminal charges. That's why, my lord, MFA 100 is also mentioned in the website of the Supreme Court.
This appeal against 42
Yes, my lord.
was preferred by the railways.
Yes, my lord. Both, my lord. If your lordship may look upon, there are two diary numbers been mentioned. 4070.
Where is the indication that this appeal is against MFA 42?
My lord, I'll just. If my lords may look upon the Supreme Court order, if your lordship may have, I'll place it.
This one.
No. What the thing? This is the order of the Supreme Court, my lord.
Okay.
My lord, two diary number are mentioned, MFA 42 and 105, both. Both are mentioned, my lord. Diary number 40703 and 40701. 40703, 40703.
MFA number.
MFA 42.
1049.
Two connected matters, son.
Okay, 2 years to complete.
Okay.
Right.
This was against 42.
42 and 105 also, my lord, in below, both were connected. In fact, my lords, I was watching the live streaming of the Honorable Apex Court at that time. 40701 is also.
Proceedings order.
My lord, two diary numbers are mentioned.
No, still 42 is mentioned.
Yes.
Only mentioned.
And my lords will look upon the next one, 40701 of 2024 diary number. Both cases were appealed, both were tagged together. I'll place the case status of 40701. I have. Yes. Here's a fuel source, my lord. Both were appealed, both were dismissed, my lord. This is the case detail of 40701 fuel source, my lord, connected. Same order, common order.
It was dismissed not on merit, lordship. Especially the application was not accepted, therefore it was.
my lord.
Okay, yes,
That's my
Miss.
first question.
Yes, Miss Devi. Whether the tribunal was right in holding that the judgment in
It was discussed in detail, Lordship. It has specifically stated that MFA 100 was not placed before the honorable single judge. Therefore, this 42 judgment, Lordship,
in MFA 100, the issue was whether the terminals are having facilities or not.
Lordship, for levy of terminal charges, whether facilities are mandatory or not.
That was the issue.
That was issue, and MFA 100, it was stated that it was not mandatory.
Yes, but that is not the issue in this case. In the present case, the issue is whether terminal charges can be imposed on for any terminal which is not mentioned in the list of 50 terminals.
50 session, they are repeatedly saying that this 50 session only in this 50 session lots of terminal charges can be levied. But this circular, it is clearly stated this is only for these 50 stations are chosen only for development purpose. It is nowhere stated that it is for imposition of terminal charges that these stations are developed. It simply is also page. It is a page 89, Lordship, of the circular 56/2007. It is clearly stated, Lordship, development of freight terminals. In pursuance of the Honorable MR's announcements during Budget 2007-2008 regarding development of freight terminals, a meeting was held on 16/4/2007 which so and so, in which 50 goods sets were identified for upgradation. These sets were identified only for upgradation. It is nowhere stated that these would be used for only for imposition of terminal charges.
No, his submission is that the notification which enables the railway to impose terminal charges came into effect from 1/7, that is on 1st of July. That is the date when the terminals were supposed to have the facilities.
Para 8 of the circular, Lordship. Zonal railways should move proposals for development of goods sets and submit them to board for inclusion in the supplementary works program by 38th of June 2007. Zonal railways should ensure compliance of the time limit. So, Lordship, this is only for inclusion of these railways for Lordship in the supplementary works program. It nowhere stated that it should be for using this.
On what basis you impose terminal?
Terminal charges are imposed as per my understanding, Lordship. First, Lordship, page 97. Circular dated 29, it was later on superseded, Lordship. Page 97, circular number 58 of 2007, dated 29/5/2007. Subject, Lordship, levy of development charges and terminal charge. Second parallel, sanction of the central government is also accorded to the levy of terminal charge of ₹10 per ton per terminal. So, Lordship, terminal charges are imposed on the Lordship goods, not on the station, Lordship. Per station, it is terminal charge of ₹10 per ton per terminal. These terminal charges will be levied for bulk and loose traffic on railway-owned terminals and sidings and not on terminals owned by customers. And illustration has also been given, Lordship. Illustration say a customer books 3,600 tons of coal from a private siding to a goods set. Charges amounting to ₹36,000. ₹10 into 3,600 ton will be charged as terminal charge, goods sets. Now, if the same traffic is to be moved between two goods sets, rupees 36,000 will be levied as terminal charge for each terminal. Thus, customer will have to pay a total of 72,000, 36,000 into 2 as terminal charges. However, if the traffic moves between two private sidings, no terminal charge will be levied. So, Lordship, terminal charges are imposed on the goods, Lordship, between two stations.
But
And it was later on also superseded by circular dated 92, circular number 92, page 99, Lordship. It rates were, Lordship, married, Lordship. In supersession of rules regarding levy of terminal charges notified by board's letter of event number so and so 29/5/2007, RC rate circular number 58 and dated 1970. Sanction of the central government is accorded to levy of terminal charge at the rates mentioned in the table below. So by this, Lordship, the terminal charges will be levied only on Indian Railway on terminals and sidings. So by this circular, Lordship, in the iron ore traffic, all other traffic and container traffic rates are fixed. These are the terminal survey, these are per ton, per terminal, these are the rates, Lordship.
so do you want to say that the railways can impose terminal charges
Yes.
on
On their goods
Indian
sets.
Railway owned
their goods
terminals which are beyond 50, the list of 50 also?
Yes, Lordship. This, Lordship, they have not annexed any circular, neither we have any circulars, Lordship, where it is specifically stated that this 50 stations will be the terminal.
Where the charges may be imposed. Yes.
Because these terminal charges are imposed only on Lordship goods.
Okay, suppose I agree with your submission, then how to overcome the SLP decision in
Yes. SLP, Lordship, SLP was without any region order, Lordship.
Oh.
Yes.
But Supreme Court has declined to admit
Yes,
the
admit the SLP.
after condoning the delay.
Delay
So
we are not inclined to entertain the special leave petitions under.
does it indicate that the Supreme Court has found your appeal devoid of any merit and therefore SLP was not admitted?
This is the, without assigning any regions, Lordship, if SLP are rejected, Lordship, it does not, Lordship, no res judicata or no merger. Dismissal at stage of special leave without region, no res judicata, no merger. Lordship, and from para 13 to 24, detailed discussion has been made. Lordship, we are on, Lordship. Lordship, 11, Lordship, page 374.
Para 19,
Para 19. 374.
374. Yes, please read.
In Rup Diamonds versus Union of India, the law declared by this court is that it cannot be said that a mere rejection of special leave application could by itself be construed as the imprimatur of this court on the correctness of the decision sought to be appealed against. Page 374,
Yes.
the second parallel. It is.
It is. Please read.
It is not a policy of this court to entertain special leave petitions and grant leave under Article 136 of the Constitution, save in those cases where some substantial question of law of general or public importance is involved and there is manifest injustice resulting from the impugned order or judgment. The dismissal of a special leave petition in limine by a non-speaking order does not therefore justify any inference that by necessary implication, the contentions raised in the special leave petition on merits of the case have been rejected by this court.
Okay.
It may also be observed that having regard to the very heavy backlog of work in this court and the necessity to restrict the intake of fresh cases by strictly following the criteria aforementioned, it has very often been the practice of this court to grant special leave in cases where the party cannot claim effective relief by approaching the High Court concerned under Article 226 of the Constitution. So Lordship, simply by a non-speaking, Lordship, rejection of special,
It does not indicate that there
There-
was a result.
yes,
There was a finding on merits.
yes, Lordship.
Suppose if I even agree to this, still there are two judgments of the coordinate bench. How to overcome that?
Yeah.
Because two judgments of coordinate bench directly hold that the terminal charges cannot be imposed beyond these 50 terminals.
That MFA 100 specifically stated that for imposing of terminal charges, it is not mandatory.
FA 100 say does not specifically deals with this list of 50. It deals with a different issue. But two judgments,
But these two judgments, Lordship, which 50 station, it does not specifically stated. It simply said as 50 station. 50 station.
Circular is mentioned.
No, Lordship, this is not the circular. It is this circular is for upgradation of 50 railway station. It nowhere stated that this will be used for terminal imposition of terminal charges, and terminal charges are only for on the Lordship goods. It does not have any relation with the development of the station. And this Lordship 42 MFA 42 or 97, nowhere it is mentioned which 15 terminal station or under the honorable court relied on which circular or rules.
no, but it says in para 10 that if any of those 50 stations, those means it is
Can you see the order of the honorable court last week? Those means nowhere it is stated the same the judgment. It's the same. The honorable court has it is a one-page judge order only, let's say. May I read it?
42.
42, I have 105 losses, same order.
I'll place it.
Same order.
42 you have.
My lord, I'll place it.
I have the 105 losses. You have also same, most probably same order.
Same orders. Same.
Second paralysis, this is third para. In this appeal, two questions are to be answered. They are whether the railway authorities can recover punitive charges after delivery of goods, and whether the railways can levy terminal charges for loading of goods in all stations. Here we are concerned with the second lordship. Regarding second lordship, para 10. Regarding the second question, there is no doubt that there are 50 specific stations. But it is not mentioned which those for 50 railway stations,
Yes.
which are those stations. having all the infrastructure for loading, unloading of goods, and if any of those 50 stations.
So you want to say that there is no indication in the judgment
That's it.
as to which 50 station it is referring to?
Anyone can say, Lordship, these stations are among these 50 station as per your convenience, Lordship.
Yeah.
My lord, a specific issue in para 3 of MFA 42 and 105, my lords may look upon para 2, issued number 2, whether railway can levy terminal charges for loading of goods in all stations, my lord. Very specific issue in all stations. Or
It says only 50 stations.
my lord.
But which 50 stations?
Which, my lord, 5/6/2000 circular, 5/6/2007 circular.
There is no reference in the judgment.
Has not been mentioned, my lord. However, my lord, 50 stations is speaking only in regard to terminal charges, only this 50 station, my
That
lord.
is your case.
I'll apply for the certified copy of MFA 42 appeal, my lord, for better convenience of the
No,
order.
MFA 42.
42 and 105. The 5/6/2007 circular has only been interpreted, my lord.
No, but the judgment does not say specifically.
Which 50 station? However, only 50 station has been specifically mentioned.
Yes,
my lord.
how to find out?
Which 50 station, my lord, in that.
Because we are concerned about the binding effect of that judgment.
My lord, my lord,
So unless it is clear,
my lord.
and that too in view of the fact that a judgment indicating something contrary, it may not be contrary, is there in MFA 100. Okay.
If my lords may permit, I'll satisfy your lordship by bringing the appeals which was preferred in MFA 42 and 105, which is solely the only issue was 50 goods shade station.
No.
I'll also bring the RCT order, my lord, if lordship may permit, wherein the issue was only
Suppose a question comes before court in
My
a
lord.
particular judgment
My
that whether it is binding or not,
My lord.
whether we will go for the records of each judgment.
My lord, if Railway Claims Tribunal, order of the Railway Claims Tribunal against which the Union of India preferred an appeal before the High Court in MFA 42, if RCT's judgment is only in regard to 5/6/2007, I'll bring that, my lord, in RCT for satisfaction, or else my lord's lordship 50 station is only speaking about this 50 station 5/6/2007 circular, which was an issue in hand in this matter, in that matter, and
Okay, I'll reserve the judgment.
My lord.
In the meanwhile, you may submit the certified copies.
Of RCT's order, Railway Claims Tribunal or certified,
Okay.
which is only in regard to 5/6/2007 circular, my lord. And
You want to bring it to only to indicate that the question was in reference to that particular circular only.
my lord, that I will bring. My lord, this 2 submissions, if my lords may permit me.
Yes.
If my lords may look upon, page number 99, based on which the railways are imposing terminal charge as a rule by issuing a mayor executive circular, my lord.
Red circulars are not the rules, Lordship.
My lord,
So it is not required to be placed before the Lordship Parliament.
page 99, my lords.
Yes.
In suppression of rules, emphasis applied on the term, my lord, rules. In suppression of rules regarding levy of terminal charges notified by railway boards, letter number so and so dated so and so. Sanction of central government is accorded to levy terminal charges at the rate of rates mentioned below. Rules, my lord. Railways are imposing terminal charges rules in the form of a mayor executive circular, my lord. Notification by issuing rules in the form of a notification would not give them right to impose new charges, my lord. It's a new charge brought in the year 2007. Before 2007, there was no concept of terminal charges, my lord. These 50 stations were developed as terminal station from the good shapes, my lord. Before 2007, there was no concept. And they are bringing a new rule without getting it passed from the parliament and imposing huge amount of charges upon the stakeholders, which are the consignor, consignee, or endorsee, my lord. My lords may look upon section 199, my lords.
Section 199 of
Railways Act. So 199. If my lord is there, section 190.
yes.
Rules to be laid before Parliament. Every rule made under this act shall be laid as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions. And if before expiry of the session, immediately following the session or successive session aforesaid, both House agree in making any modification in rule, or both House agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be on effect as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under the rule, my lord. As per this section, my lord, every rule has to be placed before each House of the Parliament.
Suppose it is not placed.
Then in the next successive Parliament session, they have to place it. And even if they have not placed it, my lord, then they cannot impose those charges, my lord. My lord, assuming that there was a Parliament session just crossed, my lord. Now Railway has passed this circular. So Railway can impose terminal charges from that period circular till the next Parliament session. As per this section, Railway can impose terminal charges from date of issuance of circular till the next Parliament session. And they have to get it passed, then they can continue imposing. But if the railways are not getting it passed from the next session, Parliament session, then, my lords, Railway cannot impose. And from that period, they can keep it from the date of issuance of circular till the successive Parliament session. From that period, they can keep it, but they have to get it passed from the Parliament. The railways are imposing rule by mere executive circular without getting it passed from the Parliament, my lord. It is giving them unbridled power, my lord. There are various, my lord, Honorable Apex Court judgment which is speaking about unbridled and excessive delegation of power to the executives, my lord. This is misuse of those powers, my lord.
Lordship, these are the railway rates of the executive Lordship.
There is no power in the act.
No, Lordship, rule section 30. Section 30 of the Railway Act, Lordship. Under section 30, these circulars are issued.
My lord, section 30 is only speaking about fixation of charges.
These facts are also, this issue has also been discussed in page 80 of the judgment. Page 80 of the Lordship, I'm afraid. Lordship, section 30, powers to fix rates. May I read it, Lordship?
Yes.
The central government may, from time to time, by general or special order, fix for the carriage of passengers and goods rates for the whole or any part of the railway, and different rates may be fixed for different classes of goods and specify in such order the conditions subject to which such rates shall apply. 2. The central government may, by like order, fix the rates of any other charges incidental to or connected with such carriage, including the
Fixation of rates is section 30 is the empowering.
My lord, section 30 is only speaking about the fixation of rate, the rate which has been already imposed, the charges which is already going on. The executive has the power to increase, hike, or decrease the rate. Example, my lord, demurrage charges, my lord. Railway can impose it 2 times, 4 times, 6 times by imposing penal demurrage charges. But my lord, it is only speaking about fixation of rate, not speaking about imposing a new charge in the form of a circular, my lord.
Okay.
Not new, sir, Lordship. It is a fixation of rates.
Only a
And these-
fixation of
these-
rates, my lord.
Yes, yeah, all these red circulars are issued under section 30, and these are also discussed in the judgment lordship at page
But
80.
this point you have not challenged in this.
I have, my lord, my pleadings are there in my appeal.
Page 80 lordship. Paragraph number 34.2.20.
Okay.
My lord, I'm not pressing the section 199 issue. Apologies, my lord. I am not pressing. I'm only I'm just keeping my case limited to section 50 good shades only, which has been upheld by the coordinate bench, and
42.
42 and 105 upheld by the Supreme Court. I'm just keeping my case limited to that. If my lord may permit, I'll place the certified copy of MFA 42 appeal, which was preferred by the union.
Yes. Third, Mr. D. Rathi, Learned Counsel for the appellant. Also, Miss R. Devi, Learned Central Government Council, appearing for the respondents. Hearing concluded, judgment reserved.
Much obliged.
And also in the judgment, it is also clearly stated that the 105/97, these are not based on a binding ratio. It is on page number 77.
Of the RCT.
Lordship.
RCT. We have to decide whether the tribunal was correct, right, making that observation. That is a point for determination in this appeal.
And also, Lordship, whether terminal charges are on Lordship station or goods.
Yes.
For this red circle, Lordship, it imposed on goods, Lordship. One station to another station.
No.
At the rate fixed by red circulars.
Now it is my turn. Wait for the judgment.
My lord. Only issue is per incurium, my lord. That is the only issue. Much obliged.
All right.
Item 6.
My pleasure, Lordship. Lordship, this was hard at length, Lordship. Only issue that remains to be, that was left for today's year
It is part heard
is pattern.
by me.
Yes, Lordship. There's only one issue, not just issue, I had said I'll give some citations. On the point whether prononciatory decision would be applicable to judgment passed before prononciatory. That was the only issue that we had.
Oh. What is your submission?
So my submission also, this will apply to the law of the EAZ. This will apply to all judgments which are, once the Supreme Court declares a law, that will be retrospective in nature, unless it is very clearly said.
Law is not retrospective.
Only when it is stated to state explicitly.
Law is always prospective.
Lordship,
Only the precedent.
declarations of law. Law is prospective. Only declarations of law. Suppose a provision was not interpreted properly, Supreme Court interprets that particular provision. That will relate back to the day of the act, not from prospective view. Unless Supreme
Yes.
Court very clearly says there are certain instances where Supreme Court said that this will have a prospective effect. It had to say by way of an like in the case of National Insurance Company versus Baljeet Court. The
Yes.
issue was earlier everyone used to be considered third party. Then these decisions came, no, everyone is not a third party, they are gratuitous passengers. So, but then since a lot of judgments had already been passed, the Supreme Court made a very categorical, this will be this will have a prospective effect. Otherwise, any declaration of law by the Supreme Court, law is substantive law will have an effect for prospective effect. But when a declaration of a particular provision was not is a new interpretation has been given.
Yes.
That will relate back to the day of the act.
Yes.
Now, see, I have some citation in general, but a particular citation only on the point of this loss of
this particular head that way. In this particular case, let's say our case, the honorable, the learned member lordship had allowed. This is judgment on that particular point. I'll give the other judgments also. What was allowed is lordship, one, loss of consortium, 2 widow, 1 lakh. Loss of love and affection, care and guidance, 2 lakhs. Loss of estate, 1 lakh. And then funeral expenses, 25. My submission was that as per pronunciation, this will be 70 plus 10% whatever is allowed increase. So that was opposed by my learned friend. That
This is the only issue.
This is the only issue. Otherwise, lordship, the appeals that I have, grounds on which I had filed the appeal has already been lordship decided that they heard by your lordship. What happened was, my issue was that age of the deceased was considered only on the basis of post-mortem report, but he has produced subsequently before this honorable court lordship the proof of age. So my ground is lost that way.
Okay.
My only issue was that people, you know, that given some proof. He has given a pension papers on which the age is very clearly. So I have lost my ground lordship. Then the next question was this particular heads of compensation. Lordship, I'll let's say this particular judgments. Number 9. This is this yeah, there's yet another 26. Even no, sir, there are various judgments. I'm just giving two. One for as a general statement of law. The other is a case related to only loss of consortium. Lordship, in this case, Lordship, Sanigra Juhi Uttamchan, New India Assets Company versus Sanigra Juhi Uttamchan. Para number 9, Lordship. There, the insurance company had contended that since that particular judgment was passed prior to prononcity, so prononcity will not apply. That was the contention of insurance company, that whatever increase was allowed 10%, that will not apply. Now, this Honorable Supreme Court Lordship has held that this will apply. If I may read this particular paragraph.
Yes.
In paragraph number 9, Lordship, in tune with the question of law, number C, the respondent insurer took a ground in the appeal contending that the High Court had gone wrong in granting amount in excess of 70,000 under the head conventional heads. In this context, the learned counsel appearing for the respondent drew our attention to the law laid down by this court in the decision National Insurance Company versus Prononcity and others. Paragraph 59.8 of the decision would reveal that this court held that under conventional heads only a total of 70%, the split up being 15, 15, 15, and is grantable. It is to be noted that after having held thus, this court went on to hold that the amounts fixed under the conventional heads should be revisited every 3 years, and the enhancement should be at the rate of 10% in a span of 3 years. Even while taking into account the said position laid down by this court in Prononcity's case, we are of the view that the tribunal and High Court cannot be found at fault with fixing the amounts in excess of the amounts fixed by this court, as the award and the judgment of the High Courts were passed prior to the pronouncement of the judgment of this court in Prononcity's case. But at the same time, it is to be noted that the decision in M.A. Murthy versus State of Karnataka and others, this court held that when in a decision this court enunciates a principle of law, it is applicable to all cases irrespective of the stage of pendency thereof, because it is to be assumed that what is enunciated by this court is in fact the law from the inception. We may hasten to add that we shall not be understood to have held that pursuant to the enunciation of a principle of law, matters that attain finality shall be reopened solely for the purpose of applying the law, thus laid. But at the same time, if the matter is pending, then irrespective of the stage, the principle cannot be ignored.
So
So then there is
Yes.
another.
even the tribunal judgment was before proneseti.
Yes, that was in 2016.
During the
Proceeding can be ignored.
pendency of the appeal,
Yes, sir.
proneseti's judgment came.
Yes, sir.
Then it will be applicable.
Then it will apply. That general statement of law has been very clearly under judgment. I have given Manus Porihar. There are some others also. I'll just confine myself these two only. That other judgment also Manus Porihar. Para 26. Very shortly, it is just 2 lines. Also. Para 26 in that judgment Manus Porihar.
Yes.
What was done in Bimle's Tanwar Supra was actually a declaration of law. Therefore, the same will have retrospective effect. In P.B. George versus State of Kerala 2007, this court held that the law declared by a court will have retrospective effect if not otherwise stated to be so specifically.
Yes. Yes. Stink.
That P.B. George's decision also is with me, Lordship.
Yes, Mr. Talab. Anything else?
And it also further goes on to say, whenever it is supposed to be doctrine of prospective overruling has to be done, it must be exercised in the clearest possible term. Otherwise,
So specifically mention has to be there
yes,
that
it will
this
have a
judgment will
prospective.
have prospective overruling.
Yes. Like in the case of National Insurance Lawsuit, I have the judgment also with me. Very clear, sir. National Insurance Company versus Baljet Court. When the question of gratuitous passenger concept had been settled down. Otherwise, everyone traveling in the vehicle is to be considered a third party. They said, no, they are not third parties, but they are gratuitous passengers.
Yes.
That is the only point
Yes,
that was left.
yes, Talab.
See, my understanding is that if there is judgment, it has prospective effect.
No. On what basis that?
On my understanding, Lordship.
No,
And
but
if there is
after hearing Mr. Goswami,
retrospective effect, that should be mentioned in the judgment itself.
no, no, no. That is wrong understanding.
And so far as they have taken 2 grounds only in the appeal. One is age and another is loss of state.
Loss of?
Estate.
Is that?
Only 2 grounds they have taken.
Okay. So you
The
submit.
ground which
But
they
at
have.
that time, pronunciation had not come, Lordship.
Lordship,
No, no, but
let him argue.
This was applied, I had filed this appeal in 2016. So now pronunciation is to be applied irrespective of when it, or to all the pending cases. This is
no,
very
no.
easy.
But for that, whether you have to take a ground or not, or court will.
Sometimes these grounds are taken during hearing stage also. When the law has been laid down, it will have a retrospective.
No.
So this court will apply no other law but pronunciation.
Automatically, it will not apply unless it is
And I made
a.
that argument during the lawsuit. Without amending, lawsuit.
Because it would put the claimant in somewhat disadvantageous position. So unless you take that ground, so that he could have answered it.
Lordship.
No, sir, but in an earlier cases, Lordship, we could not have taken them. No, even if we don't take the ground, Lordship, this court always applies the law as it is, Lordship, not what was. That was not the law at that point of time. If that were the law, I'd have appealed on that ground. That's not the law. Law came, evolved thereafter, Lordship. But it says it will have a retrospective effect. In all cases, retrospective effect has been given to even my learned friend has been taking advantage of retrospective effect in a lot of cases. All claimants do. So in this case, if the now honorable court has to take that, that is judgment, it will take into account the law as it is, Lordship. This law has been modified in the meantime, when this appeal was pending. So irrespective of stage of the matter pendency, this will have a retrospective effect. That is the whole sum and substance.
Okay. Yes.
The submission is that the ground which they have not taken may not be considered by this Lordship. As so far as if their ground is even if accepted, then also the claimants, all the claimants are entitled loss of consortium. Wife will
At
get
at what rate? That 40,000.
wife will get spousal consortium. Children will get parental consortium, and mother will get filial consortium. In this regard, there are judgments also.
That may be allowed. And 3 others.
Submit the judgment.
For 3 others under 1,20,000.
Yes, okay. Anything else?
One relevant judgment. They have accepted the same. So, and in addition to that, 10% will be increased in every 3 years.
As per the judgment of the Pranay Seth.
Ownership leadership. So, all the four claimants will get 40,000 each, and that will be increased in 10% in each 3 years.
So how much will be the increase?
This
Will be under 1,22,000.
But Pranay Sethi will increase, will be from 2017 onward only.
Lordship.
But your accident occurred prior to 2017.
That should be
You
considered.
you will not get any increase.
Lordship. That should also be
No.
considered.
Anything else?
In this regard, any judgment is required.
You can refer to judgment.
They have accepted it.
One says accept pronunciation and subsequently. But there have been, even recently, there is a judgment of the, I'm just not going detracting from my submission.
My main
That,
contention is
I mean, Lordship, just for, I'm here to only assist the court also. Recently, Lordship, after discussing magma and this thing, there is a judgment by the Supreme Court where only pronunciation was considered. This consortium to other members of the committee was not allowed. There's still a lot of.
Which judgment?
On today, I can give it tomorrow also. So some Sriram, I forgot to carry it today also. I can give it to the tomorrow also.
Yes, Mr. Talukdar, anything you?
my contention, main contention is that they have not challenged the other heads. Only age and loss of estate. So other Lordship, other aspect is there. I have filed cross objection also.
Okay, for enhancement.
That I am submitting 2 judgments.
Okay, what is your contention in cross objection?
Mother was not considered as dependent. Lordship. Mother is always considered as dependent. There are several judgments.
No, whether there is any evidence that mother is.
Evidence is not required, Lordship, in this regard. It is settled position. Mother is always considered as dependent on her son.
No, suppose mother is a working lady. Suppose still she will be.
Still.
No, what is the logic? If mother is a working lady earning more than his son,
Yes,
her son,
that point.
how she can be considered as dependent?
She is not
There
working.
has to be some evidence regarding
In that
dependency.
regard, they have to prove that mother is working.
No, claimant has to say that I.
Mother is always considered as dependent. The settled law, Lordship. Irrespective of any income of
No,
the mother. Lordship, there are judgments.
Dependency is not a question of law pure
It's a
law.
question of fact.
It is a question of fact, whether somebody is dependent on somebody else
Lordship.
is a question of fact.
It is specifically stated in her evidence on affidavit, and
That
that could not be rebutted.
Oh,
Lordship,
that
can we
is what
see
I'm
evidence?
that is
Evidence
what
for-
I'm asking.
Lordship.
Is there any evidence whether she said that I am dependent? If there is evidence, then there is no issue.
Lordship,
If I
can we
may
see
add.
the evidence of
No, Mr. Goswami. If you
evidence of
interrupt, he will.
No, no,
Lordship, can we see the evidence of wife of the deceased?
Yes.
Second, please to proceed.
Yes, what it says.
The paragraph 4, Lordship. That my deceased husband was a constable. Got it, Lordship?
Yes, please read.
UBC so and so under Meghalaya police, and he was getting salary so and so, and he was the only earning person in our family.
Okay.
And then again, Lordship, 8th line from 8th line. So due to unfortunate death of my husband, we have been facing acute financial
So
crisis.
this line that only
and
earning person implies that all other were dependent.
Lordship.
Okay. Anything else?
Lordship, in this there are judgments, the Honorable High Court and also Supreme Court. Answer judgments is there, Lordship. Recent judgment is there. And kindly see the findings of the learned tribunal, Lordship. Kindly some memo, cross objection. Paragraph, page 18,
To
paragraph
cross
35.
objection. In this judgment which you have
Lordship,
you have highlighted paragraph. Okay.
paragraph highlighted, Lordship. And recent judgment is there. In that case, recent judgment on the Supreme Court. In that case, Lordship, father of the deceased was a retired person. Retired person. And he was getting pension. In that circumstance also, the mother of this deceased was given 1/3 of the awarded amount.
So it indicates that if mother is not an earning member and her husband is earning, then still
also-
she is a dependent of both her husband as well as her son.
Lordship, both. Lordship. And Lordship, kindly see the findings of the learned tribunal at page 18, cross objection, Lordship, page 18, paragraph 35.
Whereas
In this case, paragraph 35, Lordship. In this, Lordship got it? Cross objection, paragraph,
Yes.
page 18, paragraph 35. Lordship.
Yes.
In this case, widow, 2 minor children, and mother of the deceased are claiming to be dependents on the income of the deceased. This court admitted that the widow and children are natural dependent on the income of the deceased. Hence, claimant number 1, 2, and 3 are considered to be dependent. But claimant number 4, mother of deceased cannot be treated as dependent because in the claim petition by paragraph 23, the claimants are claiming that the deceased was maintaining the treatment expenditure of his old ailing father and mother, by which this court has believed that father of the deceased is alive, or he was alive at the time of death of the deceased. It is established principle of law that when the husband is alive, his wife cannot be treated as dependent on any other person. Therefore, claimant number 4 is not treated as dependent
Okay, so
on this.
apex court has said that she can still be dependent on
Lordship.
her son.
In all the judgments, it is held that even if father of the deceased having any income, the mother should also be considered as dependent on her son.
Anything else?
So deduction should have been 1/4 instead of 1/3. And so far as loss of quantity is concerned,
All the 4 dependents will get.
4 dependents.
Okay.
In the last judgment of lawsuit, even if during the pendency of the case, mother expired, that should also be considered as dependent. During the pendency of the case, if mother expired, but at the time of accident, mother was alive, then also mother should be considered as
So
dependent.
yes, the time to be
at the
taken into consideration is the time of accident.
One small reason, also.
Yes, let him complete.
It is completed on my own.
Anything else? If anything remains, you can give it later on.
I'll give.
Yes.
So that loss of constitution, so
Okay.
13 is concerned.
Okay.
I'll give.
I'm saying, this is just one small reminder. In this last year, Lordship had said that it's a question of fact. And on question of fact, I'm making just yes, I'll leave it to your Lordship. In this case, because of the particular society Lordship, in this, it was required to prove the mother of the deceased is to stay at home, because in that society, the son gets married into a different family, not the boy gets married into a boy's family. In the Khasi family Lordship, Shillong, the son gets married to the bride's family. The
Yes.
mother lives separately, not
Yes.
not with the son.
Yes, this is very.
Like in other cases,
Lordship.
some evidence was required to be laid in this case. The mother doesn't live with the son. That's a different family.
Because in this, the cross by the insurance company, can seal. That has been specifically stated that they could not rebut the same. The mother was dependent. That could not be rebutted in cross. Lordship, can you see cross examination?
Of mother.
It is not a fact.
Yes, read, please read.
Cross examination of
Yes, please read. I am
1,
listening to.
4, 5, 6, 7, 8, 8 line.
Yes, what is
It
that?
is not a fact that my mother-in-law is not dependent on the income of my husband. I am living in a matriarchal society. It is not a fact that in matriarchal society, the females used to work and their husband do not used to do any work. The dependency of the mother could not be rebutted by the other side.
We heard Mr. R. Goswami, the learned counsel for the appellant. Also heard Mr. M. Talukdar, the learned counsel for the respondent number 1 to 4. 1 to
1,
4.
2, 3, 4 expired lawsuit. Subsequently struck off.
1 to 3. As well as for the cross objector. Stop by this judgment, this court proposes to dispose of the MAC appeal number 171/2016 filed by the insurance company, as well as the cross objection number 16/2017 filed by the claimants for enhancement of the compensation awarded to them. Stop. The facts relevant for consideration of this appeal and cross objection, in brief, are that on 14/6/2013, the husband of the claimant number 1. Claimant number 1 is the wife.
1 is wife.
Claimant number 1, who was a police personnel and was attached to Ledrimbai ADC. Ledrimbai is a place, name of place.
Yes. Ladrimba is a place.
Ledrimbai ADC, where when was executing traffic duty at Cherokee Down on National Highway number 44 and was towing an accidental Alto car from Deep Gorge. But all on a sudden, a truck bearing registration number RJ021 G5475, which was proceeding from Thangskei side, THANGSKAI sides towards Gauhati in a very and being driven in a very rash and negligent manner, knocked down him. As a result of which, the husband of the claimant number 1 sustained grievous injuries on his person and he died on the spot. Thereafter, the dead body of the deceased was taken to hospital and post-mortem examination was conducted. Thereafter, the respondent number 1 and other three claimants approached the Motor Accident Claims Tribunal Kachar Silchar by filing an application under section 166 of the MB Act seeking compensation for death of husband of the claimant number one, namely Ted Shabok Nonglaw, Nongahalaw. Within bracket, hereinafter referred to as deceased, bracket close. The present appellant contested the claim of the claimants by filing written statement wherein it took various defenses which are available for an insurance company in claims cases. Stop. The owner of the offending vehicle did not appear before the tribunal in the inquiry, and the inquiry proceeded ex parte against him. On the basis of pleadings of the parties, following points for determination were formulated by the Motor Accident Claims Tribunal Kachar. Quote A from page 12 of the memo of appeal. Stop. In support of their claim, the claimant side examined how many witnesses?
Witnesses, several witnesses, Lordship. Official witnesses also attending, Lordship.
Only one witness.
No, Lordship.
But
Three
the
witnesses, Lordship. To prove the salary, two witnesses have been examined.
claimant side examined three witnesses. Whereas insurance company,
No DW.
whereas the insurance company did not adduce any evidence to counter the contentions of the claimants. Ultimately, by the judgment and award which has been challenged in this appeal as well as in the cross objection, the Motor Accident Claims Tribunal awarded the claim of the and allowed the claim of the claimants and directed the insurance company to pay a compensation amount of rupees 44 lakhs 4,260 260 along with an interest at the rate of 9% per annum from the date of filing of the claim petition till full realization. It is pertinent to mention herein that the claimant number 4, namely the mother of the deceased, was not considered to be a dependent of the deceased, and other 3 claimants were awarded the compensation amount. Stop. Mr. R. Goswami, the learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal erred in assessing the age of the deceased at the time of the accident solely relying on the age mentioned in the post-mortem examination report. He submits that this you are not, though you have mentioned age,
Age.
are you pressing?
No, Lord, sir, I'm not, because he has produced papers.
Really? Age mentioned in the post-mortem examination report. However, when during the course of hearing of this appeal, the learned counsel for the respondent slash claimant has produced the pension book, service book,
Pension books.
pension book of the pension book means family pension book.
Only pension.
Family pension book of the claimant number 1. The age of the deceased has been mentioned therein as, what is the age? As 37 years. And as such, the learned counsel for the appellant has submitted that he is not further pressing the said contention. Stop. Learned counsel for the appellant has further submitted that the Motor Accident Claims Tribunal has erred in awarding the compensation to the claimants under conventional head of loss of estate at an where is the ground?
Prostitution only. Age and loss of estate.
Loss of state, what ground was taken?
Let's say paragraph, page 5, para 3, Lordship.
At rupees 1 lakh. He submits that the judgment of the apex court in the case of Oriental, what is the citation of Pranay?
National Insurance Company Limited versus Pranay City.
National Insurance Company Limited versus Pranay Sethi.
2017-16.
Reported in
2017.
2017-16 SCC
680.
680 has laid down the law as to how much compensation may be awarded against the head, loss of estate, and other conventional heads. He submits that in the aforesaid judgment, the apex court has categorically held that a compensation amount of rupees 15,000 is to be awarded against loss of estate, and 15,000 is to be awarded against funeral expenses, and 40,000 against loss of consortium. He submitted, stop, the London Counsel for the Appellant submits that since the judgment of the apex court in the case of Pranay Sethi Supra came during the pendency of the instant cross objection, instant appeal / cross objection, the law laid down by the apex court in the said judgment is applicable to the instant case, and accordingly he prays that the compensation awarded against the conventional heads namely loss of estate, loss of consortium, and funeral expenses, which is on the higher side, may be accordingly reduced in terms with the judge in pursuant to the judgment of aforesaid judgment of the apex court in the case of Pranay City. He submits that it is a well settled proposition of law that when the apex court enunciates any principle of law, it is applicable to all cases irrespective of the stage of pendency thereof, because it is to be assumed that what is enunciated by the apex court, is in fact, the law from inception. He further submits that it is also a settled proposition of law that the law declared by a court will have retrospective effect, if not otherwise stated to be so specifically. In support of his submission, he has cited following rulings. Number 1, Manoj Parihar and others versus State of Jammu and Kashmir and others, reported in 2022 5 SLR 543. Number 2, New India Assurance Company Limited versus Sonigra Juhi Uttamchand versus reported in 2025 INSC 15. The learned counsel for the appellant, further submits that the tribunal was correct in not regarding the mother of the deceased as his dependent, as the deceased was a married person and the society to which deceased belong is a matriarchal society where after marriage the male used to stay in the residence of his in-laws. Stop. On the other hand, Mr. M. Talukdar, the learned counsel for the respondent slash claimants as well as cross objector, has submitted that ... I'm reserving the judgment. Heard.
This name of the company it's not there. It is merged with ICICI number. I have to file a copy of their resolution.
Okay.
Bharti Exa, that is the company. It doesn't exist now. It is with ICICI.
That has to be reflected in judgment, otherwise they will get.
Yes, Lord. So I'll give you a copy of the order
Okay.
resolution, board resolution.
Okay.
And also that judgment that I have not.
And Mr. R. Goswami, learned counsel for appellant, also on Mr. M. Talukdar, learned counsel for the respondent slash claimant slash cross objector. Hearing concluded, judgment reserved.
So that's the line about statutory deposit.
Yes, yes.
So by submission, the grounds which is not taken in the appeal may not be considered.
I remember.
May please Lordship.
Yes.
Lordship, like to mention item number.
Apply this.
15 Lordship. And it fixed in the month of August, 6th of August Lordship.
Item number
14 Lordship.
14. Heard Mr. M. Ahmed, learned counsel for the appellant. Also heard Miss S. K. Laskar, learned counsel for respondent. This matter could not be taken up
6th of August.
due to paucity of time. Place this matter again on 6th of August for hearing.
Item 15, a date may be fixed.
Due to paucity of time, date at the due. Date 10 September.
My lord, 10th.
10th.
Or 14, if it could be 14 or 15th of next after vacation.
Difficult. Other remaining matters, court master will give. Oh, no, it will be shown as leftover. Registry will give dates.